Good morning, everyone. Will the October 28th, 2016 Licensing Committee meeting of the Contractor State License Board come to order? My name is Susan Granzella. I'm the committee chair for licensing. Do I hit it?
Sure. Good job.
Only board members who are members of the committee may sit at the table. Other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observing cannot participate in the discussion. We have two members participating this morning via teleconference. That would be Mike Layton is at CSLB's Norwalk office, and Johnny Simpson is in San Diego.
Call the roll. Susan Granzella.
Here.
Linda Clifford. David De La Torre. Ed Lang.
Here.
Mike Layton in Norwalk.
Here.
Okay.
Here.
Frank Shetter.
Here.
Johnny Simpson.
Here.
And you're in San Diego, Johnny?
I'm in San Diego.
Okay.
I have one member of the public here with me.
Okay, thank you. We'll do those introductions in a minute.
We will now do the committee members and staff introductions, and identification by members of the public is voluntary. Shall we start with?
Rick Lopes, Chief of Public Affairs.
Frank Shetter, board member.
Laura Zuniga, Acting Chief of Licensing.
Susan Granzella, board member.
Cindy Christensen, Registrar.
Ed Lang, board member.
Cindy Kanemoto, Chief Deputy Registrar.
Christy Shields, Counsel for the Board.
Katie Lee, Licensing Staff.
And we have a member of the public in the Norwalk office. Oh, do we have an introduction there?
Mike Layton, board member.
Bill Okamoto. Come over here.
Sir.
Just introduce yourself. Okay. Oh, let me set the camera. Right there.
Bill Okamoto, teacher at a Contractor State License School.
Very good, thank you.
Pastor Herrera, board member.
Oh, and Pastor.
Should I introduce myself?
And Johnny, down in the San Diego office, we have a member of the public. May we know your name?
Lynn Miner, member of the public.
Thank you. So this is a meeting of the licensing committee, follow on from all of the developments of our last board meeting. But first, before we go forward to, in our review as a committee, we have a commendation and we have an event to recognize Larry Parrott and his retirement today. So Larry, I would like you to come forward, if you please. So I was going to do this. I'm so glad to have you here. I was going to do this sitting down, but it just didn't seem right. I had to stand up and speak this way. And they have prepared comments for me. I guess they didn't trust what I was going to say, but this is the proper thing. But you know, it is definitely something that we all agree. So here goes. We're here today to acknowledge and honor someone who's made a real difference here at CSLB. Someone who has made a significant contribution to this board's success. Someone who has served the people of California with great distinction for more than a quarter century, Larry Parrott. Larry has had a rich and rewarding career of public service. He started working for the state June 4th, 1990. What was your favorite song back then?
I can't remember.
Oh, okay, okay. At the California State Lottery, wow. No doubt Larry didn't get assigned to work in the office where they printed scratcher or lotto tickets because he didn't quickly retire. We weren't able to take advantage there. Maybe in frustration from not winning the lottery the next year, in 1991, Larry got his first spot on the Department of Consumer Affairs at the Board of Professional Engineers, Land Surveyors, and Geologists. Cindy Christensen was the senior engineering registrar there at the time and takes great pride in taking all the credit for bringing Larry to our department. Not being one to let the grass grow too tall around his feet, over the next 9 years, Larry worked at the Department of Forestry, Department of Conservation, and in the Consumer Affairs Administrative Services and Consumer Relations units. Larry landed here at CSLB on September 25th, 2000, and made this wonderful place his home away from home for the next 16 years. Larry's first position at CSLB was manager of the call center. He then moved on into the licensing division as a manager. That's where he was responsible for helping implement our new fingerprint program and forming our criminal backgrounds unit. Larry was also instrumental in helping clean up various backlogs, probably more than various. Especially by cross-training staff and then moving them based on where the workload was. Many of those systems are still being used today. In 2006, Larry moved over to run our administrative unit. He did a great job here for 10 years, especially in the area of personnel. Always a favorite. This past April, Larry moved back to licensing when he was named licensing chief. I think it's safe to say that much of the work Larry did over the last 16 years wasn't seen by a lot of people, especially our licensees. But that doesn't mean the work wasn't important, wasn't done very well, or wasn't appreciated. I know all of us on the board have always been impressed with Larry's work and the work of all the staff under him. His goal was always to get people their license as quickly as possible, or make sure if someone had a license, they could keep working without interruption. I've had the pleasure of interacting and working with Larry during my time on the board, and here's a note that says, add personal thoughts. Well, the first day we worked together, I just have to say that in my past career, I had to work in documenting, reporting, IT, all of those things. And it was always a challenge working with people who owned the data, especially if you had grandiose ideas on how it might be changed. And we sat in that first meeting knowing what we needed to do, but I had no idea how you'd react. And he said, let's get to work. And with Charlotte there and the managers, the Cindy and the rest of the folks, you just put it out on the table and said, this is where I think we need to improve that. You knew what you were talking about, but it was great collaboration. And at the end of the day, I think in an hour and a half, we did about 6 hours worth of work. And at the end,
maybe 12 months.
Yeah. And at the end, we all walked away saying, wow, we did some work today.
Yeah.
So those are my thoughts. So before we present Larry with a certificate of appreciation for all his great work here, we'd like to give those of you who've known Larry the best over the past 16 years, the opportunity to briefly share any of your memories with Larry, if you have an inclination to do so right now. Anyone? Okay.
Larry, on behalf of staff, I just want to thank you for everything that you've done here at the board. Like Susan said, you were very instrumental in our, a lot of personnel actions when I first came to the board, and it was very helpful to me there. Also the business services side. And just even in between you going into admin and then taking over the licensing chief, just your knowledge of the call center and how things work in the licensing section, that really attributed to why you got the licensing chief. And I just want to thank you for all your work and wish you and Angela the best for your retirement. I think it's going to be a lot of fun for you guys. As you've already told me, it already has been. Angela has you to work putting knobs on the kitchen cabinet, so I'm sure there will be more. So congratulations.
Handyman work.
And thank you again.
Thanks.
Make sure you keep it under $500.
Anyone else? All right.
I would like to say something.
Oh,
This
please.
is one of those times a board member.
Like we could stop you.
Hi, sorry I'm late. Larry, I just wanted to say, when I heard you were retiring, I thought how well deserved. And you were, you know, I've been on this board a long time, and for me, you really stand out as one of the figureheads for the administration. And you just your composure, your presentations, your professionalism, and your personality. You know, you are a great man. I adore you personally. I hope that's not too personal, but looking forward to seeing you show up at our board meetings and maybe at a Paul McCartney concert.
There you go. Thank you very much, Joan.
Larry, I just wanted to say, I remember when you started working at the board, and you represented a lot of different changes that really needed to be made. And as you reminded me not too long ago, I really threw you under the bus in a meeting when you first came on board. But I got to know you, and I've got to say the thing I've always admired about you is you have handled with such grace and dignity a lot of situations here at the board that most people just go screaming with their hands up out of the building. And I've learned a lot from you, and you have been a wonderful mentor, and I am so thankful and grateful for the time that we got to work together and that we got to be such good collaborators and good friends. And I adore you, and I really, really miss you. But I don't know, anybody that deserves retiring and enjoying the rest of their life as much as you do. Thanks for being here at the board for all of us.
Thanks, Sean.
Anyone else? I know. So we have a certificate of recognition that I have here, but I'd like to read what it says right now. In recognition of more than 26 years of superior commitment, dedication, and service to the people of the state of California, including 16 years at the Contractor State License Board. On behalf of all board members and staff, thank you for your exceptional contributions and leadership as an integral part of CSLB's executive team. Best wishes to you and your family upon your retirement.
Thank you.
You're welcome.
Thank you.
So now the hard part. I'd like to ask if you have any words to share with us today.
Well, first of all, thank you very much. Working for this board has been a tremendous positive experience for me in that, first of all, learning how to serve the public and how serving the public, what that means, and consumer protection. I never really knew what it means. I always thought I was a people person, and I liked talking with people, but I never realized how I could put that to good use and it be beneficial to others. Getting a job, first of all, with the Engineers Board, and then at Consumer Affairs, and then coming here has really taught me what that really means. I've enjoyed working with all the people, the staff at the board. I've loved working with all of the board members throughout the years. The board members of this board are so concerned with staff and helping them achieve their goals, helping them achieve the board's goals. It's always was beneficial having that support as a staff person. Cindy Christensen, I can't say enough about. I've worked with her for, as far as I'm concerned, it seems like my entire state career.
Let's just leave it there.
Yeah, but Cindy provided mentorship, made me stretch in areas of experience and knowledge beyond what I had planned for myself. And for that, I'm very grateful. And those experiences really prepared me for other things in my life, being a father, being a husband. I just learned so much from working with Cindy that I just can't say thank you enough. Steve Sands also was a fantastic mentor. I've worked with him all here for 16 years, and watching Steve grow and age taught me, he's not here so I can say, but it taught me the gracefulness that a human being and a man has as they grow older, and I want to use that for myself as I get to be older, and especially as I'm now retired. But again, thank you very much, Susan. I greatly appreciate your kind words and the words of the board. And it's been my pleasure. Thank you.
Thank you very much,
Thank you very much. It's nice.
Thank you. Okay, so I love it when I get to do fun stuff like that. Recognition for people. So, let's do the public comments. Okay. Did I read this one? Yeah. My first time as chair, so bear with me. So, public comment. This item is provided, reading this? Okay. This item is provided for public comment pertaining to items on the agenda as well as items not on the agenda. However, the committee cannot take any action on items not listed on the agenda. The CSLB welcomes public comment on any item on the agenda, and it is the CSLB's intent to ask for public comment prior to the committee taking any action on any agenda item. But if for some reason we forget to ask for public comment on an agenda item, a member of the public desiring to comment on the item should raise their hand or speak up on the teleconference, and they will be recognized. Also, we will be limiting public comment to 5 minutes per individual. Are there any individuals that wish to address the committee at this time? Yes.
Hi, my name is Janie Ricketts, and I own a commercial piece of property in Midtown Sacramento. I would like to bring to the, I sold to the state of California for 25 years. And I know how caring, and specifically to various boards. I would like to relate to you my experience with the contractors department. Initially, I didn't want to go to the board or go to the department. I had a licensed general contractor build out 3 suites within my building, and he promised me that he would build it to code. At that time, I was having personal financial problems, and I was not familiar with, even though it was my building, with running that building or doing any construction whatsoever. My friend, the general contractor, assured me he would build it to code. I thought perhaps I would be fined, but I believed him. Long story short, he did not build it to code. I didn't want to get him into devastating trouble by turning him in, so I took him to small claims court. He lied profusely, and I lost. I didn't do a very good job of representing myself at that time. It was way too personal. However, I eventually did come to, and I called the department, and I said, now, are you here for the contractors? Are you here for the general public? And they assured me that they were here for the general public. I submitted my documentation, which was about that thick. When I turned it in, the gentleman said, wow, your caseworker is going to love looking at this. And he said they would get in touch with me. The woman that called said she looked over my file, she talked to the general contractor, and he denies doing, like, for example, the showers, the commercial showers that were built. And I said, really? He's the only general contractor I have had. And she says, well, I'm sorry, he didn't build them. And I said, well, I have pictures of his crew building. Oh, no, we can't take pictures. I said, well, how about some of his employees that worked on the job? Oh, no, we can't talk to employees. And I said, well, it's in the paperwork I gave you. I know it's very long and laborious, but I can show you exactly where he did the showers. And she says, oh, no, I can't see you. So I said, well, let me get, turn to page, and I said, see right there, he bid on it. I paid for it, or he invoiced me for it, and I paid for it on the following page with the check that you see right there. Oh, I guess he did do the showers. And I get, yes, he most certainly did. She doubted me much. She finally turned me over to another gentleman, or to a gentleman, that said, well, gee, you lost in court. There's nothing we can do for you. And I said, well, it just so happens that the week after the court date, the city of Sacramento cited my building as a dangerous building. And I now have documentation that it was not built to code. Well, there's really, okay, well, maybe we can do something. And it went on like that. Finally, I kept insisting, and they did. I was speaking with an inspector. They finally had an outside contractor come in, and I had not gone through this process before. And I didn't have all the documentation that they needed. And so ultimately, they said that there was nothing that they could do for me. And the contractor would be fined $500. I have to take everything down. I spent about $70,000 on the build, and I have to take it all down and put it back up again. Frankly, for the damage that he did and for the damage that I see being done by various folks, $500 is not a bad rap for doing whatever you jolly well want to in a building. And I just wanted to bring it to your attention. It's a done deal for me. But I do feel that I called and I spoke to another gentleman, and I said, this just doesn't sit real right with me. And I said, I know I lost in court, but he lied. And he said, look, your investigator's butt's on the line. He is not going to, unless you can prove without a shadow of a doubt that he did the work, there's nothing we can do. And I said, but I have all this stuff. He said, I'm sorry. I'm sorry. So I did want to bring it to your attention. I know it's, I can see by your faces that you're not real pleased with this, but I really felt you needed to know. So there we are.
Thank you for bringing that to our attention, and I'm pretty sure that our Chief of Enforcement, Dave Fote, will probably look into the situation. I mean, since we don't have all the facts and everything.
Of course.
Of course, we can't take any action on it, but Dave will look into it again.
Oh, I didn't
Okay.
expect that. Thank you very much.
Thank you. So the next item for the licensing committee is really an extension of what we started at the board. Oh, I'm sorry. Thank you. Are there any comments from our remote locations?
This is Norwalk. Seeing none.
Johnny?
This is San Diego. No, we don't have any.
All right, very good, thank you. So, back to, yes, and I'd like to note that Dave Delatorre has arrived here in Sacramento in the hearing room. And I understand the Bay Bridge was not a fun place this morning.
No, not at all. And I apologize for being tardy, so.
No, we're very glad you're here. So this will be not a line-by-line review, but more or less a time for the licensing committee, and that includes testing. We made some changes in the way we report, reducing the time of staff to prepare the documents, as well as reducing the number of graphs and pages, and putting the critical reporting in this format that you see here. And we first reviewed it at the board meeting. This will be another review, and as I said, line by line, I believe it's best that we get to the point. But it is an opportunity now that people they've had a chance to review it, is to, if there are any comments on the way the documentation is there, in modifying it, in updating it. We did remove some items that were redundant. We've done a couple of other things, but more importantly, are there any comments about things that you would like to see? And that would be obviously first comments by our committee. And so let's go through this again on page 9. I do want to note there is a correction. As with any first draft, this is always a work in progress, remember. We do have a correction on page 9, down on the bottom where it says total applications received prior fiscal years, where it says FY 14-15, instead of 29, that should be 37,672. We're still putting the final touches on all of the Excel spreadsheets to pull the data from the internal database. So I do want to note that. But we've put the data into a consistent format through here and trying to emphasize really the volume of the data, total number of applications, so that we could see what we've done in the prior 12 months. And by review, what did we do in the last 5 years? How many more, less? What are the changes? How, and hopefully we've engaged the staff to be able to tell us any exceptions that they've noted that may not have a place in here, but any other exceptions, changes, something they note in the way that we're either serving the contractors or the consumers. On page 10, this would be the total number of applications processed per month. And again, that's the format we're going for the past 12 months. And what do we do in the last 5 years? And you'll see that the numbers do fluctuate, but we feel that this is the best way. As we make any changes to these systems, it will be the best way for us to gauge how we're going to handle the volume based on prior years, knowing what was going on. We also had applications are processed down at the bottom. It turns out that processing application, I know I learned this, is much more complicated than just simply an intake and adding and processing really the application. There are many, many things that take place. So now that we have standards that are stated in the documentation of what that process is, taking that into account. Disposition of the applications by fiscal year, and that's a snapshot. And remember, we have the pending. There are reasons now stated in the documentation. Why are they pending? How are we following up? So in fiscal year 2015-16, 39,972 came through, and they were processed and issued. 19,000 void, and then pending, which are carried over to the next year. On page 12, this was the one pie chart we all agreed was very helpful because it takes a great deal of time and effort to monitor the workers' compensation certification process. And now we see we have something that's visible, workers' comp coverage for the active licenses, 223,477. And then what we had put in recently were active license classifications on page 13. And this was obviously effective 8/1. It's being updated. But now that you can see, we're able to know by classification the number of exceptions. If there's anything that is suspicious or anything we need to look into or why is this happening, we'll be able to see this now by classification. On page 14, the fingerprinting and criminal background unit, these are the numbers. Obviously, we are at the mercy of some outside agencies to keep these statistics up, but as of August 1st, this is the kind of processing they've been doing. An experience verification unit, they've made some improvements in that area by standardizing documentation, trying to standardize documentation that's submitted with your application. So we have the statistics here, experience verification. Remember, we have to do a minimum of 3%, and this is where the statistics withdrawn, verified, denied, and appealed. On page 16, we have experience verification by classification. Further detail on what we do with that 3%. On page 17, especially critical, very important, the Licensing Information Center and the support services, the call center. And, it's always astounding to me. I was a board member, new, and how could anyone answer that many phone calls? Well, they have qualified, talented, now pretty much up-to-date staffing taking care of these calls and able to do other things as well. Again, the format for the documentation, these are the stats for the last year, and here are the prior 5 years below. The judgment unit, what we have done is put this is money that is they are able to process these and recover these funds, and it's the judgment unit for liabilities, judgments, and payment of claims. This was before on many different tables and pages. We've consolidated on one. The bottom line is, of course, that the combined monetary savings for the department was $49,811,000. There's a ring to it. 266. So it's a very important number. On page 20, and this is really our one of our critical ones, average weeks to initial processing by month. And this fluctuates, but the improvement has been dramatic. And you will see for the original exam and waiver, the average weeks to processing. Well, of course, that takes 2 days for the cashiering. Isn't that what it is? Yes. And of course, there's the week. But more importantly, the time has been reduced. It's critical. They've been able to reduce that time and report to us in a logical way what those improvements are. I thought, was an incredible effort from 9 in December down to 2.5 weeks in July. And that is for the licensing update. And what I wanted to do to ask committee members at this point, if there are any statistics that, or any changes or comments that you might have of additions, any, changes or comments that you might have. And then also, if in the future are there any other comments, passing them on to Laura, who's standing in for the licensing group, before we go on to testing. Okay? So.
First of all, fantastic work. This is really excellent, and I'm thrilled that so much improvement has been done. I have a couple of questions about, and these could be part of just the first processing, but on page 14, I'm not sure I understand where the totals are coming from. They're not the totals of the fiscal years, so what, perhaps I'm missing something.
Which column are you talking about?
Okay, I'm looking at the far right. If you add up the DOJ records received, 18,000, 18,000, 20,000, 28,000, 32, 3,000, it doesn't add up to 366,000. I'm not sure exactly what it adds up to. It's probably 100 and something, but it doesn't add up to 366.
Yes, Charlotte, please.
If you look at the second, I just want to yell from my chair.
Right.
Okay. If you look in the body of the script, the second paragraph talks about how we removed several of the fiscal years prior to that just for the sake of having a 5-year average. So if you look on that second paragraph, it provides you with information about the numbers prior to that, which are added into that total.
So if we're just really looking at the 5 years, shouldn't we just stick with the 5-year total and go ahead and take out?
We can certainly do that.
Yeah, take out whatever's before.
Sure.
Okay.
Okay.
I mean, I would suggest that so that it's kind of like an apples to apples kind of a thing for the rest of the tables that we're doing too. Thank you. I appreciate that.
You're welcome.
On the experience verification statistics, the numbers that are here are not 3% of the numbers that are of the received figure before. So, and there may be a different kind of tie-in there. I just think that, just so we don't have people saying, well, you're actually not doing 3%. You're actually doing 1%, or 1.5% or whatever. So I'm looking at Charlotte because I'm sure she has the answer.
You may just want to stay up there.
Okay. So as you know, we implemented the computer drawing of the 3%.
Right, objective.
I can't remember what month that was actually.
Yeah.
But since that has happened, it's spot on 3%. Prior to that, the procedure differed, and we were getting those applications that didn't appear to be meeting our minimum qualifications were being routed by people.
Okay.
So that is the biggest difference, as we are strictly doing the 3%
That's
computer.
fantastic.
Exactly as it states
Well,
in the law.
I love the fact that it's objective. I mean,
Yeah,
you're
it's
just
very-
reaching in, picking up an application, bringing it in, taking a look at it, and that way you don't have people saying, well, you're picking on me or anything else. right?
Correct.
Yeah.
Correct.
That's great. So that happened at some point here, and so we'll start to see numbers that'll actually be a lot closer to the received numbers as we go forward, right?
Yes.
Okay. I had another question. The licensing program update for the, and I don't know if it's easy to do this or not, but is it possible that we can put the dates on the charts?
Which chart?
I'm sorry, on page 16, when you're looking at the licensing program update, there's no date on this chart. You can go back to the narrative and it'll tell you. But some of the dates, some of the charts have dates and some of them don't have dates.
No, I think that's good. I think
If we kind of went uniform and just put the dates in the titles of each one of the charts, then when we were looking at it, we'd know exactly. I mean, it is there. You do have the information there. It's just not in the same spot. And I had one more question. There's not a chart here for, and by the way, the improvement in what you guys have been doing is amazing, and you're doing a fantastic job. And it's clear that you can see the improvement, not only in the numbers, but frankly in the way, just the culture and the way people are responding and everything. It's all really good. There isn't a chart on here that tells us once you start that initial processing, how long does it take to get a license? And I'm wondering if that's something that's reasonable, because I know that people have impact on whether they get the license or not. Because once we start, I mean, if we start processing it, that's great, but if they have not given us the information, or they don't go to the testing, you know, they get sick on the day of testing and have to reschedule, or something happens, right? They start impacting our ability to actually give, you know, get them a license, right? So I don't know whether measuring from initial processing to actual time of license is something that means something when there's so many outside our control type things that impact our ability to get a license to you, right? I mean,
right.
Is that true? I mean, is that a true statement?
Right. So on page 20, of course, is the average weeks to initial processing.
Right.
Which is when they
fantastic.
begin. But
right.
the thing that's so problematic about trying to average that is everything is based on the applicant's response to information we need from them. Right. If the application requires some correction and we turn it to them, are they going to return it right away? Or are they going to wait till 90 days?
Right.
And then once we have an acceptable application, we post it. Are they going to appear for their first exam, or are they going to keep stringing that time along? Because they have 18 months to pass. And then once they pass and they receive their bond and fee notification, they have 90 days. Are they going to send their requirements in right away? Or are they going to wait till the end of that time period? And then as we try to be courteous to our applicants, we will even allow them a 30-day extension to that time to submit the corrected application, to test, to submit the issuance requirements. Because it's all predicated on their personal behavior, it's almost impossible to track that.
I agree, and I think that's kind of the place I was coming to, was we really have so little control. Once we start processing and we tell them this is what you need, we have very little control over whether they see it as a sense of urgency or they don't.
Correct.
And you know, we're trying to, especially in the LLC range, because I know we've had so many kickbacks, we've tried to, and I mean that in a nice way, of course, we've tried to get people to understand that they really need to pay attention to the LLC situation when they come in, and yet we still get them without their statement of information.
Right.
Or without their correct names of who's really actually in that LLC and on, you know, and responsible for the way the licenses are issued to LLCs.
Right.
So, okay, this is fantastic. Those were just a few comments. I think you're 100% right that, you know, we can measure right up to the point where we have control and we're responsive and we're giving them everything they need. And at that point, we really have to rely on how badly they want to be a licensed contractor.
Exactly.
Thank you very much, Charlotte.
You're
welcome. Thank you very much, Chair.
Okay.
This is Johnny. I have a question.
Sure.
First of all, I'd like to say thank you. This is very well laid out and easy to read for all of us. I think it's great information. My question really is on page 12 and 13. When we start talking about workers' compensation, and this sort of brings home some of the stuff we're talking about on the state levels and all of those things, and the underground economy and all of that. When I see I believe it's 56% of our overall licensees are claiming exempt, that they have no employees. I mean, that's a huge number to me. I guess I see on the agenda that under the enforcement committee, we do have a workers' compensation enforcement plan. Are we going to be addressing some of that in that committee?
Hi, Johnny. This is Cindy. Yes, we
Okay, good. I'll reserve my questions then.
Stay tuned.
Me too, gotcha.
Okay. Any other comments from our committee members? Any comments from the public? Either here in the room or remote locations? Okay. So next we have an update, which is part of licensing, which we have asked Randy to go ahead and give our update. And again, Wendy had been instrumental in changing, working on the documentation, assistant with licensing, and it was a learning experience for all of us, and a very good one, so thank you.
Well, I'll be brief. You'll find the testing report in the packet starting on page 21. The exam administration numbers are up. We continue to use our test centers for civil service exams. The Consumer Services Representative exam was given in August. We're in the process of filling 2 vacancies. All of our occupational analyses are on the 5 to 7 year cycle. We have 4 exams in the occupational analysis phase, while 8 of them are in the exam development phase. We released the new C39 roofing exam in July, the C33 painting and decorating exam in September, and then this month the C17 glazing exam was new. We continue to administer the Consumer Satisfaction Survey monthly with the annual report in the spring. Are there any questions for me?
No questions, but it's nice to see the trend continue across the year going up. So I know that makes you more busy, but that makes us more happy. So it's good to see that we're doing more and more tests.
It seems an upward trend that we can believe.
Since we don't get to see the consumer satisfaction survey until annually in spring, what are you seeing? I mean, are you seeing things that are making you comfortable and it's going to be a good report, or?
I want to focus the agenda item on materials and what you're seeing and how it's being presented, because that's the agenda item that you have in front of you. So you might want to put that on another committee agenda.
Okay.
Thank you.
Thanks. Thank you, Wendy. And I think that if there are any questions from committee members, any questions from committee members about the testing? That is a first. All right, is this better? No. Okay. Much better? Right. So any comments from our committee members?
Could I ask that the client survey be put on the next agenda so that we could just have kind of an interim feel of how it's going? Thanks.
All right. Any comments from the public, either here in the room or at our remote locations? No. And I just say we're adjourned. That's it?
Also requires you to do a first and a second to adjourn.
I'll write that down.
First,
Second.
Susan Granzella.
Aye.
Linda Clifford. Aye. David De La Torre.
Aye.
Ed Lang. Mike Lee.
Aye.
Frank Shutter. Johnny Simpson.
Aye.
All right. So we are adjourned.
Will the October 28th, 2016 Enforcement Committee meeting of the Contractor State License Board come to order? I am Marlo Richardson, the committee chair. That's loud. Only board members who are members of the committee may sit at the table. Other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observing cannot participate in the discussion. We have a board member participating this morning via teleconference. Pastor Herrera is at the CSLB's Norwalk office. Board member Kevin Albanese has an excused absence. Heather, will you please take the roll?
Kevin Albanese, absent. Susan Granzella. Here. Joan Hancock.
Here.
Pastor Herrera.
Here.
Ed Lang.
Here.
Marlo Richardson.
Here.
And Frank Shetter.
Here.
Thank you.
We now do committee member staff introductions. Identification by members of the public is voluntary.
Rick Lopes, Chief of Public Affairs.
Frank Shetter, Board Member.
Joan Hancock, Board Member.
Dave Foe, Chief of Enforcement.
Marlo Richardson, board member and chair.
Cindy Christensen, registrar.
Ed Lang, Board Member.
Susan Granzella, board member.
Cindy Kanemoto, Chief Deputy Registrar.
Christy Shields, Counsel for the Board.
Heather Young, Enforcement Analyst.
I'm excited to start this meeting by commenting. Right. Is there anyone in the audience that would like to introduce themselves? If so, please come up to the podium. Or stay seated.
Jimmy Fremgen, Assembly, Business and Professions Committee.
Chris Walker, member of the public on behalf of Cal SMACNA.
Dave Diaz, board member.
James Goldstein, Air Resources Board. Warren Hawkins, Air Resources Board.
Martina Diaz, Air Resources Board. Amber Foreman, Public Affairs.
Dennis Ward, Director, Sacramento Electrical Training Center.
Mike Janetsky, Enforcement Division.
Holly Loader, Enforcement Division.
Steve Grove, Swift Unit. Richard Markson, Pacific Advocacy Group.
Stephanie Carr, Politico Group.
Mike Johnston, Public Member, National Electrical Contractors Association.
Todd Sachs, Air Resources Board.
Fernando Galley, Department of Consumer Affairs.
Blake Williams, Northern Swift.
Irene Crowder Johnson, Northern Swift.
Allison Adams, Northern Swift.
Greg Hampton, Northern Swift.
Lori Miles, Northern Swift.
Claire Goldstein, Public Affairs. Ashley Caldwell, Public Affairs.
David Delatorre, CSLB, Board Member.
Northern Swift.
Georgia Silver, Northern Central Swift.
Jason Stoddard, Northern Swift.
Jeff Miller, Northern Swift.
Missy Victor, Enforcement. Kayla Bosley, Swift.
Linda Clifford, Board Member.
Doug Galbraith, Enforcement Division.
Jesse.
You say Jesse? Jesse Flores? Deputy Chief Enforcement?
Pastor Herrera, Board Member.
All right, thank you. I'm excited to start this meeting off by talking about some of our SWIFT team enforcement, and it's glad to see many of you present here today. SWIFT has constantly shown their dedication to consumer protection by literally hitting the pavement to perform proactive investigation at active construction sites. SWIFT is on the lookout for unscrupulous licensed and unlicensed contractors who violate license and workers' compensation insurance requirements. So far this fiscal year, SWIFT has completed 765 cases, of which 395 or 50% that went to legal action. SWIFT's success was achieved because of highly motivated and dedicated employees like the employee that I'm about to recognize today. Georgia, will you please come up? So forgive me if I mispronounce your last name. Solorzano. Okay. So we have our enforcement representative to Georgia, Solorzano, and the committee is pleased to recognize the performance and accomplishments of longtime CSLB employee Georgia. who is currently assigned to the Central Statewide Investigative Fraud Team in Fresno. Georgia joined the Contractor State License Board over 28 years ago on March 4th, 1988. She worked her way up through the ranks from office assistant to office technician, consumer services representative, enforcement representative 1, and since January 2015, enforcement representative 2. During her 28 years with CSLB, Georgia has worked in offices in Ventura, Buena Park, Norwalk, Azusa, Oxnard, and Fresno. Did I miss any? It's a lot of offices. It's evidence of Georgia's long career that 4 of the 6 CSLB offices have either closed or moved since she's worked there. As Fresno's only enforcement representative 2, Georgia has been acting as the area's lead investigator for several months when their enforcement supervisor left CSLB to go to another agency. Georgia did not hesitate to step up at this critical time and agreed to serve as the area's acting supervisor. With the approval from the Department of Consumer Affairs, Georgia began serving as an enforcement supervisor 1 in a temporary, out-of-class position on November 1st, 2015. She enthusiastically and capably performed all the responsibilities of area supervision while continuing to work on her cases as a field investigator. Then, in May 2016, the area's full-time technician retired, leaving the staff with limited clerical support. Georgia grabbed another hat from her rack and began handling much of Fresno's office clerical duties as well. And if these accomplishments were not impressive enough, Georgia has also acted as a field trainer and mentor to 2 new field investigators in the Fresno and Monterey areas. So for her tremendous dedication and to the Contractor State License Board and for your exemplary performance, the Enforcement Committee would like to commend you and honor you as your Enforcement Representative 2, Georgia Solorzano, with the Certificate of Recognition. Thank you again, Georgia, for your dedication. Is there anything you would like to say?
Yes, there is.
The button on the mic.
I'm not a fancy public speaker, but I do want to say a few things. First of all, I want to thank David Vogt and Steve Grove for allowing me the opportunity into this position and to grow and develop into, I feel, a leader. It's been a difficult challenge, but I have learned so much. And I'm really grateful because Steve has been a wonderful mentor to me. He is one of the easiest supervisors that I've been able to go and approach and talk to. And he has guided me and directed me in a very professional manner. The office in Central Valley, I was going to run stats and bring them today. Through Steve Grove and myself, we were able to get some production going in Central Valley at last. And I really want to say that I'm very happy to have been promoted to the ER2, and I am very happy to have been given the opportunity to act in the capacity of the supervisor, and even as the ER2, the lead now, I'm glad that we're still working together to make Central Valley grow. I called one of the case managers on another matter a couple of days ago, and she mentioned to me that Central Valley has the most legal actions coming through the office. So I just want to say that I'm very proud of that, and I'm really grateful that both David and Steve gave me the opportunity, and thank you, Steve, for being a wonderful mentor. Thank you.
Are there any board discussions on this item? No. Okay. Agenda item B, public comment session for items not on the agenda and future agenda item requests. This item was provided for public comment pertaining to items on the agenda as well as items not on the agenda. However, the committee cannot take any action on items not listed on the agenda. CSLB welcomes public comment on any item on the agenda, and it is the intent of CSLB to ask for public comment prior to the committee taking action on any agenda item. But if for some reason we forget to ask for public comment on an agenda item, a member of the public desiring to comment on the item should raise their hand and they will be recognized. Also, we will be limiting public comment to 5 minutes per individual. Are there any individuals that would wish to address the committee at this time? Okay, we'll be moving on to agenda item C.
Can you just check at the other location to see if there's any public comment?
Pastor, do you have anyone with you that would like to make any public comment?
No, he does not want to make any comments.
Thank you.
Thank you.
Agenda item C, enforcement program update.
Thank you. If we could turn to page 34. What I'd like to do is cover for you four highlights that relate to our efforts to prioritize and assist the elderly when they've had a difficult time with a contractor. And if you see at the top of page 34, we included a highlight titled Full Refund for Elderly Homeowner. And what it does is it demonstrates staff's commitment to achieving restitution for consumers when possible. And we'll talk a little bit later about our statistics and our success in achieving restitution, but this is an example of how when a consumer has been harmed, especially an elderly consumer, we do move quickly to see if we can't resolve it to both the consumer's satisfaction but also to the contractor's satisfaction. The next three highlights relate to elder complaints that we've received where somebody's over 65. We do note on the complaint form, we do ask them to tell us if they're over 65. Some do, some don't. But it helps us to gauge whether or not we have a higher percentage of elderly people filing complaints than others. But at the bottom of page 34, we have a highlight titled Contracting Duo Harms Two Elderly Victims. And this highlight describes a recent investigation that resulted from a $41,000 contract for a solar system. And it morphed into additional work. And ultimately, the 84-year-old homeowner had paid out over $328,000 for work that was valued at $88,000. We see this all too often. It's a real concern. I spoke to one of our investigators down in Southern California today regarding a similar case, and she's in court on a preliminary trial for a case that almost mirrors this exactly. In this situation, the Sonoma County DA has filed multiple felony charges against the contractors involved, and we'll be reporting at future meetings or in the registrar's report on the outcome of this criminal filing. The charges included 3 counts of theft from an elder, 2 counts of diversion of construction funds, perjury, and also an aggravated white-collar crime enhancement because the fraud exceeded $100,000. If you turn to page 35, you'll see a highlight titled Warrant Issued for Unlicensed Contractor Who Defrauded Elderly Woman. Unlicensed contractor Kevin Harrell fraudulently used a license number that didn't belong to him to induce a 78-year-old consumer to pay him $78,000 for minimal work. In a situation where somebody doesn't have a license, may not qualify for a license, but uses somebody else's to convince them that they are licensed, convince them to contract with them. On October the 11th, Mr. Harrell turned himself in to Contra Costa County authorities, and he's facing criminal prosecution, another investigation that we'll be continuing to report on. The final elder abuse highlight I wanted to provide, or at least to summarize for you this morning, is one titled Unlicensed Contractor Convicted. On July the 21st of 2016, unlicensed contractor Peter Cassell was convicted of contracting without a license and after requesting and receiving $8,000 for which he performed minimal work. Didn't see a lot of time for this one. He was sentenced to 3 years probation, fines, restitution, and community service. We certainly hope, though, on some of those where there's, or especially over $100,000 taken, or it's a repeat offender, that we're going to see more than just the community service. But that is the world we live in today, where they're looking for other alternatives to putting people in prison. And so it's something, though, that we are conscious of, and we are working very closely with the DAs to make sure they continue to understand just how important our investigations are and how important it is to protect the public from these white-collar crimes. On page 39, we've included a staff training update, and we're very fortunate to have with us today Doug Galbraith. Many of you have met Doug in the past. He's a retired CHP captain. He's also been our trainer for the last few years. Maybe, Doug, it seems like it's been a long time, but I was wondering if you could come up and, okay with the chair, if you could come up to the podium, Doug, and talk a little bit about the training that you've completed, the training that you've got proposed, and also what your ideas are for mentoring staff for promotional and development opportunities.
My name is Doug Galbraith, as I was introduced, and I have drawn a lot of experience, but I've had a lot of support in the past, and since I've been here at the Contractor State License Board. We've developed a CSLB Enforcement Academy, and although not a mandatory academy, I'm really pleased to say that not only our managers or supervisors, but almost 100% of our staff has been through this Enforcement Academy. We've had 5 so far, and we're going to be launching our 6th one with new hires. That's usually the base of our academy now, is people that are joining the Contractor State License Board. And we have a 40-hour course for them when they come in, so that the skills that they can get introduced to or practice during the academy it really assists them in the jobs that they have. So thank you for the support. I'm sure that everyone knows that my partner in crime is our liaison from the deputy, or he's a deputy attorney general. And from a lawyer perspective, a cop investigator perspective, I think it's really a good mix, so that they can come away with a feeling of confidence to do their jobs. We've done upper division courses also to add to the academy, and we pretty much exhausted that. And now we're doing specialized training in our specialized units in order to enhance our operations, specifically in our SWIFT unit. And I was approached by executive management not too long ago, and we all talked about how our most important asset is our people that work here at the Contractor State License Board. And it's a very comprehensive job. The laws are complicated. There's a lot of exemptions and exceptions to the law, and to understand what they do is one part of their job. But we discussed a mentoring program that we're launching, and it's really twofold. One of the first parts that we're going to be doing is to encourage our people to attend. You know, they can get busy in their work, but to make an investment in them, we want to assist them in their career choices and maybe even the prospects of upward mobility. And we want to make that investment by offering a course to them to get them to realize that it is a complicated job, and there is a lot of different disciplines at the Contractor State License Board. And a lot of times we get focused on one of those disciplines, and when you go for upward mobility and you've concentrated and done a really good job in one of the disciplines, it really doesn't equip them to be very competitive as a candidate. So we want to address that, and we're working with CSLB personnel in that, and they're going to give the nuts and the bolts of how to fill out an application that has a lot of substance to it, that is accurate and very thorough, how to write cover letters. And then the second part of that, hooked up with an enforcement manager, And we are going to go through the interview process and and how to learn the different disciplines. It's not that they have to be assigned there, but there's ways for them to acquire the knowledge and the experience of the different disciplines. And then we're going to end that training by having a mock oral where we're going to have someone that's going to nail the interview. But we want to give an example to the people of what a successful presentation during an interview looks like. The other part of the mentoring program is we've developed a checklist, pretty comprehensive. The enforcement managers really developed that. I don't want to take credit for that. But it's a very detailed checklist, and it's almost like field training. I can relate to that as a policeman. It's almost like a break-in period. But it's very detailed. It has a lot of categories to be signed off because we don't want to assume that our people get the knowledge and the skills that necessary to do their job, that we're not doing it standard throughout the whole state. So we're going to implement this checklist, but we're also going to train the mentors that will be in charge of the checklist so that we can gradually introduce our people to new positions and have all the exposure and the training that they need in order to be confident in the jobs that they do. And then we're going to, follow through and ask the people, was this helpful to you, and did this help you? Like I said, and I'd just like to thank you for your support. We do have an ongoing training program. It's given me life after retirement. But the amount of support and the comprehensive nature of CSLB work it's a challenge. And we don't we haven't seen all that we can do. There's a lot of things that we can enhance operations. We can make better investments in our people so that they can choose their career path or be in a position to promote. And a lot of it, this training, it not only serves for the individual to gain the skills, but it also builds their personal portfolio. When they testify in court, when they go for upward mobility, when they meet with our allied agencies, it gives them the position in order to speak or to be involved in operations, and they can prove it. So if you have any questions for me, the training is outlined for 2016 on page 39 and page 40, as David said. But if you have any questions, I'll be glad to entertain them. If not, again, thank you for the support that you've given me and a lot to my partner, Mike Franklin.
Thank you, Doug. I just want to say a couple of things about the training program. When I talked to Dave about Georgia, we discussed some of what we were doing as far as training and mentoring. So I'm also very, very happy and pleased with what you guys have put together. It looks very, very detailed and very promising. And there's two parts to working in enforcement. You always have that structured interview portion, the application portion, and then you have the actual job. The two don't always match up in terms of what you're expected to know versus what you actually do. So it's nice to know that you guys have really put together something very comprehensive for people to get the whole picture and, like you said, build their oral resume as far as their knowledge and being able to present that in an interview. So thank you very much for what you guys are doing.
Okay, and I heard that you will want to get involved in that, and I appreciate that. And that will be really meaningful to our staff and the board members, and you know who you are, have stepped up. Like for a graduation, it means a lot to our people when they graduate, and to have the board support and their presence during graduation, it really endorses the program, and I really appreciate that. Thank you very much.
Absolutely. And just one more suggestion or a thought maybe. Some sort of ride-along. I know you're familiar with that, but some sort of ride-along maybe where they're going through a small process of actually seeing what a day in that position would be like.
Yeah, that
might be helpful.
That is a big part of our checklist, and there's several ride-alongs that they will have to do, and I can relate to that. But they will go there, and the person that is mentoring them will have these sign-offs for their contacts with the complainant or the contact with the respondent or them working with the industry expert. So.
Perfect. Thank you.
All right.
Any board comments on that?
Madam Chair, I have a comment.
Yes.
This Pastor.
Go ahead, Pastor.
Doug, so nice to have this new system in play. It's a new toy for Jesse here.
Yeah.
It's working great. Doug, congratulations on your training program and the effort that you're doing for the staff there. And I just wanted to echo the chairwoman's comments. We're really happy that you're moving forward, you're taking the initiative, really being visionary in this whole area. And I just wanted to ask you about the SWIFT training, and specifically on page 39, about the STING training. One of the topics there is rights to privacy. Privacy, of course, is in our consumer world and our personal world is a very important issue. In fact, Consumer Reports, just their November issue, has a whole section on privacy and how to protect yourself as an individual. And I just wanted to know, what aspect of privacy are you dealing with in your training? That's my first question.
Well, a lot of it is really grounded in case law. And when our investigators go out and they're doing their job, they really parallel what law enforcement do. And as we know, knowledge is everything. And having the knowledge of what people's expectation of privacy is and what the law says, we want to respect the homeowners and the people that we come in contact, because we want to be in position that we do have a job to do, but we need to be in the proper place legally in order to conduct legal business. And our investigators going through the course, and we talk about the rights to privacy, it's all about respect and knowledge of the law.
There is an organization in San Diego, the Privacy Rights Clearinghouse, that I don't know if you know about it, but they have a lot of good information. I'll be happy to share that information with you at a later date. And the other question I had, which as a thought, and I saw on page 40 here that you are doing the career advancement class also. And as I was listening to the public speaker in the licensing meeting about customer service and how you deal with customers, maybe you might be thinking of maybe looking into customer service training as another opportunity here for the organization, because that's always so important, how you deal with your customer. But just a thought, and I know I was personally in my own role as a director here in LA, very, very concerned about public, how we deal with the public. Just another thought there.
No, I appreciate that thought, and I do like what I do see, but it does need to be reinforced with training, and I 100% agree with you. I mean, how we're viewed, first impressions, how we follow through with the people that we come in contact, it's a high priority.
Thank you.
You're welcome. Anybody else? Okay, thank you very much.
Okay, if we could turn to page 41, provide an update regarding our complaint handling. You'll see at the top of the page that as of the 1st of October, the pending caseload was 3,216, and that's 74 cases less than our optimum caseload of 3,290. And why this is important is we want to make sure that our field investigators, they're carrying less than 35 complaints, and that our consumer service representatives that initially handle the complaint, they have less than 60. The reason for that is we want to be able to provide timely service to our customers, to our consumers that are filing these complaints, and to the contractors, so that we can, if possible, resolve the violation. On page 42, we've included our settlement amounts, and one thing we do look to do, and when possible, is to recover money for injured parties, and that avoids both parties, from being the contractor and the consumer, from having to pursue a very costly civil action. And you'll see that for this calendar year, we've recovered more than $13 million, and that, if that continues, we will have collected more restitution for injured persons in 2016 than we did in 2015. So something we report to our staff. We encourage them to do all they can to resolve complaints when it's appropriate. We know some contractors or some complaints need to result in a legal action, but many don't, and we do look to resolve 70% of our licensee complaints, and when possible, with restitution. On page 43, we have a chart that tracks our average complaints investigated and closed monthly, and you'll see that the average remains at 10. And while this is important, is we have to be very conscious of the complaints that we're receiving and make sure that we have the resources necessary to handle them so that we don't obtain a backlog. The good news is that we have maintained a very high production average in the enforcement program, and it's enabled us to continue to handle the complaints coming through our door. We're on pace for 2016 to handle more than 20,000 investigations, which is slightly more than in 2015. On page 43, you'll see that we have a chart regarding the age of the cases, and while we have more than 3,000 open complaints at any one time, we always want to make sure that we have less than 100 that exceed 9 months in age. And so there's always going to be a small amount that haven't been closed or the investigations haven't been completed for various reasons. And those reasons can be that you have the need for a search warrant, you may have an audit, there may be a situation where the consumer is having to get architectural plans developed. As you heard from the public speaker this morning, it's kind of interesting. She mentioned about permit issues. Well, if somebody didn't get a building permit, we may not know initially what it will take to comply with code. It may require an architect to draft plans and then the building department to review those and determine how you can correct that project, and that can expand an investigation. But again, we want to make sure we handle our complaints timely, that we don't have more than 100 at any one time exceeding 270 days in age. On page 44, we've included a chart for the breakdown of legal actions. And we want to work as closely as possible with district attorneys. And we do that because if we have a bad contractor that doesn't deserve to have a license, we can achieve suspension or revocation through the criminal proceeding, which unfortunately can be, or I didn't say unfortunately, but can be more timely than administrative action. So we do work closely with DAs on the most egregious matters, and you'll see that we're hitting about 30% of our legal actions being referred to local prosecutors. On page 45, we've included a breakdown of SWIFT legal actions. And you'll notice that 50% of those investigations performed by our SWIFT staff, it's really a shout out to them. They've done a great job. They're identifying projects that are likely to have a contractor on site that's violating the law, and that's demonstrated by 50% of those investigations resulting in a legal action. And 606 of the more than 1,100 legal actions this year did result in a referral to the DA for criminal prosecution. Now, what those generally are is unlicensed practice or a contractor that has workers with no workers' compensation insurance policy. On page 47, this is a chart that was provided to us by the Labor Enforcement Task Force. The director of that is the director of the Department of Industrial Relations. And the reason we wanted to include that is just to really thank Department of Industrial Relations and the Labor Enforcement Task Force for continuing to make construction the #1 industry that they spend their resources on. You'll see in that chart that 44% of their inspections related to the construction industry. And just the final highlight I wanted to provide to you is on page 48. And we've been looking at our legal action expenditures, and for administrative cases, the cost to put on an appeal is quite high. It can be as much as $9,000, and we know that we have to file accusations against contractors that don't belong in the marketplace, an accusation being to suspend or revoke the license. But we also have a lot of citations, and half the citations in 2015 resulted from an industry lead, or it resulted from a consumer complaint where there might be an alternative to handle it in a different way, and that's through our arbitration program. And so what we've included here, we have the arbitration cases initiated, and what we're seeing in 2016 is that we have a 20% increase in referrals to the arbitration program, and interestingly enough, we're finding that we have a 20% decrease in citation legal action appeals. And so that is going to save the board a lot of money if that can continue. So it's something we're looking at very carefully. Can we continue to use arbitration in lieu of a citation when appropriate? And if so, it provides for very timely resolution to a matter. The contractor pays that fine, or pays, if the contractor is the one that has to pay the award, and sometimes the contractors do prevail, But if the contractor doesn't prevail and pays a time, there's no disclosure on the license, and it can be handled within about 60 days. So it's a very good alternative to handle the less egregious the investigations, provide a timely disposition that could be beneficial to both parties. And that would conclude the update, unless there's any questions.
I have a question and observation. I'd like to commend all of the outstanding statistics that you provided and also the results. And to me, it shows the hard work of individual staff members and also your staff people. However, on page 44, I just want to make sure that we don't have another unit. It's SWIFT, right? Instead of swoop, you're adding on page 44 at the bottom?
Yeah, yes. We definitely have a typo. Thank you.
Okay. I thought you were going to slip one in on me, but I know that you are partnering quite well out there, and that's very notable. Thank you. The other one is to give notice to all of the information I've been receiving, and I'm sure the other board members have in the committee, of the outstanding work individually that your people are motivated, the focus. And that's outstanding, and it makes the CSLB second to none. I appreciate that. Thank you.
Any other board comments?
I have a question. David, on the citations issued, how do those figures compare with, I know this is probably not the fairest question, but if anybody can answer it, I know you can, but in the last 5 to 10 years? How do those compare? Is it looks like a, 10 to 6.
Well, if you go back the last 5 years, we have to, I think citation, maybe Mike could also weigh on this, Mike Chemniski is one of our analysts, but citations have increased substantially, about 70% in the last 5 years. And I'll tell you, there's a reason why. And it's because of the board adopted policies regarding permit and workers' comp enforcement. And so what we're seeing is that we're writing more citations for permit violations. Again, we heard from a member of the public today that talked about perhaps one of those we're going to look into more carefully, but also for the workers' comp, and the board received additional staff to handle misdemeanor convictions. So contractors that are licensed, they go out and they get convicted of a misdemeanor. We're now writing citations on those. So citations have increased in the last 5 years about 70%. In the last couple of years, part of that 70% is slowed down. But in real numbers, it's about 700 citations a year. In 2015, we received approximately 700 more citations in 2015 than we would have received around 2012.
And specifically, the ratio is what I was interested between the licensee and the non-licensed. Is that consistent?
Yeah, the non-licensees have remained fairly steady, but we have some of our SWIFT staff here with us today, and what we really want to look to do with a non-licensee complaint is make the referral to the DA. And the reason for that is, while the licensee citations are effective, because if the contractor does not comply with the final decision of that action, the license would be suspended and revoked. With a non-licensee site, the recourse for someone that doesn't comply is to refer it to a collection agency, and our success in collecting our civil penalties against unlicensed contractors is about 20%. So when possible, we want to refer that case to the district attorneys in the various counties if they're receptive to receiving it. So those haven't necessarily increased, but the referrals to the DA and overall legal actions relating to our proactive enforcement for unlicensed practice have increased.
Thank you. Thank you, Chair.
Any other comments?
Madam Chair, I have a question.
Yes.
Pastor. On that same page, David, on page 48, by the way, I also want to commend you and the staff for their very, very competent and efficient work in this field of enforcement. I know it's a challenging area, but it's one that is, I guess, the heartbeat for the organization. David, you mentioned in this section on arbitration that there's an increase in number of cases that are being referred to arbitration. And I was looking at the number there that there's, I guess in this report, there was cases initiated is 553 and decisions received 384. Is that creating a backlog for you in arbitration cases? And does that cost the contractors board money every time you refer a case to arbitration?
Yes, just for background purposes, the Contractors Board contracts with Arbitration, Mediation, Conciliation Center, AMCC, to handle our arbitration referrals. So when the staff are they're investigating a complaint, if it qualifies for arbitration, the parties to the complaint fill out a submission form, and that submission form is referred to the arbitration provider, who handles it from that point on. So there's not a backlog at the Contractors Board as far as handling these. I'm not aware of a backlog at AMCC, but this might be, Jesse Flores, our Deputy Chief, is a little more, he's more hands-on with the arbitration program. Jesse, would you want to comment on that?
Right. There is no backlog regarding arbitration. Once we're referred to AMCC, AMCC handles the complaint, coordinates them, and schedules them statewide, and so it has no impact on our enforcement program. So,
Good. That's great.
Does that answer your question?
Yes.
Okay.
Yeah. That's a win-win, I guess, for both ends. Yeah.
Yeah.
And we've identified more cases that qualify for arbitration, which reduces us taking an action in a citation. So, and that's why we have more referrals and our citations reduced.
And Jesse, would you want to comment on the cost of the program?
I don't know. There is a cost for every case we send arbitration, mandatory arbitration, and voluntary arbitration. The mandatory arbitration has a threshold of $15,000 if someone's financially injured, and I believe that's just under $500 that we pay to the AMCC for every mandatory arbitration, opposed to a citation, which is about $9,000. So, and then for voluntary arbitration, I think it's just under, I think it's $700 or $775, in that range.
I think they may be getting around a little over $1,000 now for the voluntary. It's about $1,000.
Thank you very much.
Oh, Madam Chair, I have one other question. And just speaking on what Pastor was saying, on cases exceeding us on 43, 270 days, Dave, when you transfer a case, does that still tied to CSLB?
What this number reflects is the date that complaint was received. So if somebody files electronically, it's the date that we received the complaint until the date the investigation is closed. Now, it's a very valid point. If we make a referral to the arbitration provider, yes, we track that separately. So the date that we make that referral, the cycle time that you're looking at on page 43 would stop. We track the referral to the arbitration provider separately. It's a whole separate set of numbers. But I don't know, Jesse, if you are aware of I believe that their cycle time from the time they receive, this being AMCC, receives that referral to the award being rendered, I believe it's around 60 days.
It's actually less than 60 days by the time they receive it and by the time they have a decision. So it's very effective.
Great info. Thank you.
Any other questions or comments?
Madam Chair, I'd just like to echo Ed's and Pastor's comments about what a wonderful job enforcement is doing and how much I appreciate it as a board member. Thank you.
Thank you, Frank. Any public comment? All right, moving on to agenda item B, a presentation by the California Air Resources Board, CARB, regarding partnership opportunities utilizing the CARB off-road mobile sources emission reduction program. On September 12, 2016, CSLB Enforcement Division staff met with representatives of the California Air Resources Board, the Employment Development Department, and the Department of Industrial Relations to discuss partnering opportunities to enforce the requirements for emission compliance, as well as contractors' licensing and tax and workers' compensation insurance at large road-scale highway projects. Meeting participants discussed outreach opportunities, interagency memorandums of understanding, and various enforcement strategies. Here today from California Air Resources Board, we have the Enforcement Chief, Todd Sachs.
Thank you for the opportunity to speak today. I'm excited to be here. I'll start off by giving a little bit of an overview of the Air Resources Board and what we do, then talk a little bit about our off-road rule and opportunities that we see for potential partnership here with the board and David's team. Obviously, air quality is an issue in California. Everybody reads the newspapers, you hear about it. To address air pollution, the federal government passed the Clean Air Act in the 1970s. The state has parallel legislation. Actually, the Air Resources Board has been itself in existence longer than any federal programs to clean up the air and was born out of efforts to address smog in Southern California in the 1940s and 50s. The Clean Air Act, passed by the federal government, establishes ambient air quality standards that the state is required to meet. And to do that, we develop what are called statewide implementation plans. And we develop those plans in coordination with local air districts that are located across the state that work on local air quality issues associated with stationary sources. The Air Resources Board has responsibility for developing emissions control strategies primarily for mobile sources. More recently, we've had increased responsibilities put on us such that now we look at toxic air contaminants from all sources, criteria pollutants primarily from mobile sources, but also from all sources, and we also regulate greenhouse gases that impact the state in terms of climate change. So as part of these state implementation plans, the state and the Air Resources Board develops regulatory standards that apply to a wide array of mobile sources, from trucks to off-road equipment. We regulate emission standards from cars. We actually developed emission standards for cars long before the federal government started doing that. So we have a long history in doing this work. And ARB has an enforcement program that works to enforce these rules. As mentioned, my name is Todd Sachs. I'm the chief of ARB's enforcement division. I'm a scientist by trade. I've had the job about 1.5 years. And my job is to try to achieve with our team of staff compliance with all of the regulations we have in place. As I mentioned, we regulate cars. If you've read about Volkswagen lately, that's one of the things we've been working on. We also regulate parts for vehicles. We regulate sources at ports, including ocean-going vessels. And one of the things we regulate are construction vehicles and equipment that are used by contractors to build everything from roads to buildings and the things that we all live, work, and rely on in the course of our normal business. So the off-road rule places certain requirements on what we term fleets, but really they're contractors who have equipment. One of the things those fleets need to do is to register their equipment with ARB. When they do that, they get a sticker. It's about this long. It's red and white. And it provides essentially a license number for that vehicle and is required to be displayed on both sides of the vehicle. In addition to that, there are idling restrictions longer than 5 minutes, and there are emission standards that the fleet is required to meet that vary based on the size of the fleet and provide declining emissions requirements over time such that the fleet continually gets cleaner over time at a pace that's more quickly than they would normally otherwise do in the course of their business of turning over their equipment and managing their fleet under normal operations. This rule is important to the ARB. It's part of a suite of in-use emissions control programs that we put in place that reduce exposure to smog-forming pollutants and toxic air contaminants, especially diesel particulate matter, and which has a strong impact on exposures to children and populations in disadvantaged communities, which is a buzzword these days in the state. And so this program is important to us, and we want to ensure compliance with the program. There are new compliance requirements coming down the pipe in 2017, and we see some challenges with ensuring compliance with that, with those requirements. The regulations requirements are going to continue for some time. So we were excited about the opportunity to talk to the Contractors State Licensing Board and Dave's team because we think that there are opportunities for partnering so that we can So we get something out of it in terms of being able to go to facilities, but we also get something out of it from the perspective of learning about how the other agencies approach their enforcement and trying to build synergies across the various teams that are involved in these inspections. Off-road equipment, this is one of the challenges we have in off-road equipment is that contractors can operate anywhere in the state. Contractors can come in outside of the state, and it's important to understand that if you are a contractor and you're operating in California, you are subject to the requirements regardless of where you are based. We think there's a lot of value to partnering with the licensing board, strictly from the perspective of when fleets start to understand that we're working through the regular process of government as a whole, that they'll see that we're serious and that we will ultimately be successful in achieving compliance across the fleet. There are, at times, fleets that are not in compliance with the requirements, and in general, what we've seen is those fleets are often smaller fleets, smaller businesses. They may not be aware of regulatory requirements. We have a strong outreach program to try and ensure that fleets are compliant. But when they are not compliant, that may also mean that they're not in compliance with other requirements as well. And so we think that there are opportunities both where you see noncompliance, we're also likely to see it as well. So I guess I will close by saying we're really excited about the opportunity to work with the State Licensing Board. We're interested in looking for ways in which we can partner. The program is very important to us, and it protects the health of all Californians, and so we appreciate the opportunity to present to you here today and to work together in the future. Thank you.
Thank you, Todd. Is there any board discussion at this time?
I have a question. I remember when I was first on the board about 2007, a fellow by the name of Steve Matich, who was a committee member, board member, and this issue came up back then, and then the recession came subsequently after that. So how does this mirror what was started back then, and what do you see going forward as changes or
that's an excellent question. So I'll go into history a little bit about it. The Air Resources Board adopted the off-road rule in 2007. And at the time, we were also adopting a number of different rules which apply to portable equipment and trucks. Pretty much anything that operates on diesel is now regulated by the Air Resources Board. And in 2008, the recession hit, and it caused a serious impact to the construction industry. In recognition of that, we took the rule back to the board in 2010, and the rule was substantially amended. As a result of those amendments, the compliance requirements were spread out over a much longer period of time, and the compliance pathways were focused more on replacement and repowering of vehicles to engines that meet current emission standards, rather than focusing on the implementation of retrofits, which, while still an option in the rule and may be beneficial to some fleets, is not really the focus. So the rule was amended as a result of the recession. Industries had a tough time climbing out of it, but now we see that the economy is getting better for them, and that's important for the state of California for many other reasons than just for the purposes of air quality. But we think that the rule is going to be stable, and we're looking forward to achieving compliance with fleets across the state.
Yeah, I'd just like to add a couple of things. A lot of what Todd talks about, it tracks what we're trying to do with our partnering state agencies in combating the underground economy. And we did have a meeting where we invited the Labor Commissioner staff and Department of Industrial Relations to be part of it, because as most of you know, you now have to register for public works projects. And so what we're doing is, we have done, is we've taken that list of contractors that are registered for public works projects, and we've separated out the A, general engineering, and the C12 highway and road contractors, so that we can match them up with the list with the Air Resources Board. We're also going to be looking at contractors that are registered, that same group of contractors, to see if they have workers' compensation insurance. Are there any prevailing wage violations? And what we wanted the committee to consider is just to we want to let you know what we're proposing to do, and you can let us know if you have any concerns. But what we are proposing is that we're going to do 3 or 4 inspections at highway projects, and we're going to be looking at, one, are the contractors on site, and they may well be subcontractors, registered with ARB? Are they registered with the Department of Industrial Relations? Do they have workers' compensation insurance for their employees? Are they paying prevailing wages? And EDD wants to play a lead role in this to make sure that there's tax withholding on the workers on site. So that's what we'd be looking to do in 2017, is to go out and do 3 or 4 inspections with our partners and invite the Air Resources Board to be part of that.
Thanks, Dave. Any other discussion on this item?
Just to clear up one thing, so the ARB would actually be responsible for doing their portion of the inspection. We wouldn't be training our people to do any of that type of work.
No, it says the Contractors Board staff will be focused on whether the contractor is licensed and has workers' comp. They would be taking the lead on whether they're registered with them. 100%, yes.
Any other board discussion on this item? Public comment?
Hi, Richard Markison. I think we would compliment the board for this additional effort. And although it's not under your purview and would be on the responsibility of the DLSC, we would encourage that in these joint efforts on public works projects that they also carefully review the utilization of apprentices, which is a mandate on public works construction as well.
Thank you. Any other public comment? Okay. Moving on to agenda item E, workers' compensation enforcement update. Dave, can you please give the committee an update on the enforcement of workers' comp?
Yes, thank you. We could turn to page 52. You'll see in the middle of the page, we've included the 5 board-approved strategies to combat the workers' comp issue, and that you heard earlier in the licensing committee meeting that now apparently it's 56% of our licensees that have an exemption on file. We know that's far too high. I won't read for you the 5 strategies. It's in the packet, but what I want to do is update you on what we've done in furtherance of those strategies. And so at the bottom of page 52, what we talk about is the letters that we sent to contractors that we have reason to believe have workers and haven't let us know about their employees. And what's interesting about that is we had I think about a 10% compliance rate. The contractors that got the letter, 10% of them obtained a policy. What we did is we looked at an additional 30 that had websites that, in our opinion, clearly showed they had workers. You see them in a boom with all kinds of workers up trimming trees, doing road projects, you name it. So we opened 30 cases, and in the last 2 weeks, we called all 30 of those contractors. And I think it was fascinating. In making those phone calls, we obtained an additional 5 policies. So 25 of the others, I think there was 3 or 4 that didn't respond to the call at all, but for the rest of them, they had a lot of excuses for not having workers' comp. They're working for their brother, they're not actually working at this time, just a lot of different reasons. We have a spreadsheet that wasn't in the packet because I just received it yesterday. But it was interesting about all the excuses they have, and maybe some of it is justified. They're armchair contractors, they don't actually employ anybody, they use all subcontractors. I mean, that's the kind of thing we learned in doing that study. As far as the top of page 2, we're still looking at the consumer complaints. Consumers do indicate, we ask on the complaint form, did your contractor have workers? If so, do you know who they were? And generally they'll say yes, they put the names down, and we're still having success in suspending licenses for not having the policy. However, a contractor can refile an exemption and avoid having the license suspended. Most of this work's been done at our intake mediation centers. Jesse Flores has been going out and he's participating in staff meetings with all of our investigative centers. Jesse, could you just quickly talk about that? You've had how many meetings now?
I've had a couple meetings, and I'm scheduled to go to all the other IC investigation centers. As Dave said, the intake mediation centers they use this tool very well. So I just want to go into staff and remind them that this is an excellent tool. When we conduct an investigation, as you heard in licensing, during a licensing committee meeting, it's hard for one contractor to do the work without having labor. So I'm just reminding staff that when they get information in a complaint form during their investigation, that this is an excellent tool that we could suspend a contractor and hopefully gain compliance. So I hope to be finished before the year's out. Before the year's out, to be at all the investigation center, reiterating this tool that we've been had in existence for some time.
Thank you. And as part of the Joint Enforcement Strike Force, we're in the process of conducting an analysis of the 6 classifications that the board approved us to look at, and that's under number 3 on page 53. Franchise Tax Board had some ideas on how we could do that, so we're letting them take the lead to a certain extent. But just to give you an idea of what we're looking at, I mean, one idea is we're looking at these trades and we're out there doing inspections with our partners. How often is it you just have the owner on the license doing the work? Probably pretty rare, so that's something our SWIFT unit needs to be looking at. There are other states that have done similar studies, the Franchise Tax Board, so we should look at the state of New York. They've done a study, so we're doing that to see about these classifications. How often is it that an A or a C8, somebody's doing concrete work, would work all by themselves? We're going to be looking at, EDD has their, what they call it, they have a database called the ACES database, and they're going to be doing a review of contractors that are registered as employers, try to figure out how many of them actually have a workers' comp policy. But we're looking to bring that study back to you when it's completed. And that might be of some assistance if there's any consideration in the future by industry or others in sponsoring legislation to require a workers' comp policy for a certain classification. And mentioning that, we want to talk to the Roofing Contractors Association, because you may recall that that is the one classification where all C39 roofing contractors have to have a workers' compensation insurance policy. See how that's working and whether they did a similar study. On page 4, something to think about, whether we could develop a webinar for somebody that we tell them, you had employees on this job and you were going to impose a suspension unless you get a policy, but they don't get a policy, they file a new exemption, maybe they should need to view a webinar, something our partners wanted to have them watch, because it could explain why workers' compensation insurance is so important and the significant risk they're taking when they don't have a workers' comp policy. So it'd be something we would think about. Maybe that would be something the Public Affairs Committee would want to address. LETF, we have Steve Grove, the manager of our SWIFT unit, here today, and I spoke to him yesterday about the inspections, and you're probably seeing in some of the registrar's reports that we've really stepped up our investigation for workers' comp violation, putting up some very impressive numbers, and that's because our partners within the LETF, and that's the task force that performs the on-site inspections. We're out just about every week looking at job sites. They're focusing on workers' compensation insurance requirements. Number 6 is to develop materials that can be passed out. We're revisiting the materials that are available in our test centers. Our state agency partners are wanting to put together something that may be brochures or something that would be very easy to understand for applicants and industry to understand what the requirements are. So the Joint Enforcement Strike Force, that's under Employment Development Department's leadership, is looking to put together something for all of us. So we're very excited about that. Number 7, these are meetings that are held by the Department of Insurance. As many of you know, the Department of Insurance has a $30 million grant fund that exists to investigate and prosecute workers' compensation insurance violations. I should clarify that's mainly to, they pay for deputy DA investigators, but it's primarily to prosecute workers' comp violations. They do have monthly meetings. Steve Grove has dedicated staff to attend these meetings. It's so beneficial that we have a face at those meetings because it helps us to develop our partnerships. It can also help us with our sting operations and getting backup, law enforcement backup. So I think we have a couple of meetings planned. We have one the first part of November that we'll be at. The day labor centers, we're opening complaints up against day labor centers for investigation. I don't know if you're familiar with those, but that's where we have day labor centers that are allowing, they really advertise for services by unlicensed people to go out and perform construction-related projects. Now, that can be fine as long as there's a workers' compensation insurance policy in place. And we need to explain to the public when that policy is required. We don't want the public to be misled into thinking the homeowner's insurance will cover workers' compensation insurance coverage when it will not. But also so that these day laborers are not acting in the capacity of a contractor without a license. This is a a partnership that we've developed with the Department of Insurance. So this would be the Contractors Board and Department of Insurance working on this. We've opened some complaints. We're focusing on 2 right now to do outreach. We already completed one, we call it the Great and Day Labor Center, where we did reach out to them. We met with them, and they have great disclosure on their website now. They understand the need to protect the public. It was a real success because now, ideally, everybody's in compliance with the law. So that was our first one. There's another 30 to go, but it's something that's in place. We're establishing confidentiality agreements with our partners to do a better job of sharing information. So important when you have employees that are going to DLSE and making wage claims, saying, I work for this employer didn't have any workers' compensation insurance. We need that information. We know that we have workers that are seriously injured, they're killed on job sites. We need that information when they work for an uninsured employer. So we need to make sure that we have the confidentiality agreements in place so they can share that information. So that was 9 and 10. And those are that's like our top 10 list. That's what we've got going on with workers' comp. We certainly welcome any input from board members or industry in how we can be more effective.
Is there any board discussion on this item?
Madam Chair, great report, Dave, on the workman compensation. Since we're having the feedback on reasons why contractors are not getting their policies, would it be possible, or would it be infringing on their private right to list these and somehow in our public relations bulletins, or reason why people claim that they, I'm sure they're ridiculous, but are not getting workman's compensation policies? And because this is a great consumer protection issue, because homeowners probably think, oh, my homeowner policy will cover it, and it will not. So these are some of the things that I think about when I look at, especially the seniors, and it'll kind of deter if they say, well, I'm going to use this excuse. Well, they see it in the bulletin, they can't use it because it's already been recognized. What do you think about that?
Well, it would be my pleasure to provide our Chief of Public Affairs, Rick Lopes, with that information. Absolutely. We have it all right here for you, Rick.
Yeah, certainly. That's one of our main outreaches. We talk a lot when we do anything with the media, and as far as outreach, we always are talking about workers' comp. So any other ideas or vehicles, we're happy to work with them and do that.
Okay.
I would just like to say, if we're going to include something like that in our public outreach, to not give them the ideas, but to maybe just kind of discuss what they should be looking for. That's fun. That's true. Is there any other board discussion at this time? Any public comment? Okay.
Madam Chair, I have a comment, Ms. Pastor. Dave, not to give you more work down the road or add to your plate, but something you might want to think about in this area of workers' comp. As many of us know that there's a Proposition 51 on the state ballot, which is, interesting enough, being sponsored by the construction industry. And it's basically funding for K-12 and community colleges facilities. And it's going to be an initiative for $9 billion. So, and it's kind of interesting because, you know, and you kind of, when I was thinking about this, I said, well, how are you going to monitor this, or how are you going to know which projects are going to be on the board to be developed? Well, the initiative does indicate that any projects to be considered have to go through the state's facilities program through the Office of Public School Construction. And I guess all projects for the community colleges will have to go through the Chancellor's office. So, I mean, if this does pass, you know, there's going to be another area that I guess you will be monitoring. But there is ways that you can kind of monitor it through these two organizations at the state level. That's my comment. Thank you.
Thanks, Pastor. Any other board comments or public comment? Okay, moving on to agenda item F, review, discussion, and possible action regarding strategies to reduce solar energy contractor fraud. Dave.
Well, thank you. On page 57, we have a summary of our outreach to other state agencies such as the California Energy Commission, Public Utilities Commission, what we're doing with the association, the Solar Energy Industries Association, and to the other states. And so we're really looking at how we can have a very comprehensive response to the type of solar complaints that we're receiving. And what I wanted to touch on is some of the trends and what we're seeing. And last, I think it was the October 20th, I had the opportunity to make a presentation to the Public Utility Commission. It was an industry meeting. It was in San Francisco in an auditorium, and I was able to lead it off. And what I explained to them is that majority of solar projects are being installed appropriately. Consumers are happy. They're doing a great job. It can be very beneficial. Unfortunately, though, there's a handful of contractors that are creating a problem, and some are not licensed. Others are hiding in the shadows. They're predatory contractors that have been revoked in other states. We need to weed them out of the marketplace. We have a number of cases that we've referred to district attorneys, and convictions have occurred. Licenses have been revoked. We had 2 people arrested down in Fresno yesterday for elder abuse, grand theft, other violations. That's the kind of thing that we need to avoid happening. And this meeting, I believe, came about because I had been contacted by the Public Utility Commission. They're receiving a lot of complaints from people about solar. The question is, what can we do? And I said, what I think we need to do is consider a consumer education packet. There needs to be information that's available, kind of like one stop. Where would people go for that information? And at the meeting on the 20th, I was told to just simply focus on the problem and not the solutions. So I'm waiting, though, until they come back with a possible solution. And I hope, and this is what I've asked them, I hope the solution is that they will have on their website and available information for consumers, also for contractors, but generally for the consumers, so that they can make an informed decision when they're thinking about contracting with solar. And now here's the reason why. I want to provide a summary of the 3 types of complaints that we're receiving. And I learned a lot at this PUC meeting, by the way. There was a lot of industry people there. The association was there. It was very eye-opening for me. And I really want to compliment the association and the contractors in attendance for wanting to be part of this solution. Now, the first kind of complaint we get, we call it power purchase agreements. And so what's happening with the power purchase agreement is that these are just related to the type of consumer complaints that we're receiving. So I don't know about the power purchase agreements that are working out really well because people are satisfied not filing complaints. But what's happening here is that, and part of it is because of electronic contract signing, which you can have a contract signed electronically, but the law is clear that before work starts, the customer is to receive a complete copy of the contract. Now, the problem that happens on some of these sales is that the person that's presenting this contract is using like an iPad, and the consumer is not truly reading the contract. They're just initialing a page, maybe signing at the bottom, and they tell them, "We'll email it to you later." But what the result is we have a contract where somebody is agreeing to pay on a power purchase agreement more per kilowatt hour than what the public utility charges. Now, what the PUC said is that they don't believe that's lawful. I don't know that it is or not, but I know that we get complaints where they're paying 15, 18 cents a kilowatt hour, and if you go to, and here in Sacramento, SMUD's website, they're selling power for 11 cents baseline per hour. So they're paying more now than they would have before, and that's a concern to the consumers when they were told they were going to save 20 to 30% on their energy costs. That didn't happen. Also, the power purchase agreements generally require that you pay for the power that's generated and not used. So you have a consumer saying, I had no idea that while I was at work, nothing was on, I'm paying for the power my solar panels are generating. Now, I learned at this meeting that that's okay if the power is being sold back to the public utility, but of course the problem there is, will the public utility pay you the same amount of money that you're paying on your power purchase agreement? And some of the contractors, some of the larger ones no less, have put on their websites that energy costs are anticipated to rise more than 5% a year. And the study done by the utilities, who were also at this meeting, PG&E, Edison, and a lot of them were at the meeting. That's not what's happened in the past, and that's not what's expected in the future, that energy costs for the public utilities are going to raise by that amount. I think generally they raise about 2 to 3% a year. So it's misrepresentation to sell a contract. The consumer doesn't truly understand what they've signed, and that's why they're now filing complaints against the power purchase agreements. And a lot of the print's so small, we're dealing with the, I'm just saying some of the people reading them may not be able to read it as carefully as they should, and they're multi-pages, very confusing. The next type of complaint we receive are the lease agreements. And those are interesting in that they're sold that's not going to cost you anything up front. They take your last 12 months of energy bills and they tell the customer you're going to save X amount of dollars, and this will pencil out over the 20-year lease because the rates are going to raise by 30% or something over that period of time. May or may not be true. But the problem is the rates, the lease agreements generally escalate very quickly. And when I was giving my presentation at that meeting, it was interesting that I mentioned that we're seeing on these leases where they have these super liens, as we call them, on the title, and they can't sell their house. Well, an attorney that was at that meeting said it's not true. You're not supposed to be able to file a lien on a lease. And so during the break, we had this big discussion. I don't know if you can legally do it or not, but I do know we're getting complaints where people have leases on, they're being told they can't sell their house. And so that's another reason why we got to get information out to the public and even to the contractors so they understand what the rules are. And the third is the purchase agreements, and this is kind of we call it the green funding, and this is where a lot of things are happening with this. Generally, if you're shopping around and you're purchasing an agreement or purchasing a system, it would be like bidding or finding a contractor to remodel your kitchen or put your roof on. If you can shop around, it's apples to apples, makes sense. You can make a good decision on who you want to hire. So in general, the purchase agreements work okay, but the problem that we have with some of the complaints is that the consumer is led to believe they're dealing with a government program when it may not be a government program. The interest rates are anywhere from 8 to 14%, so they're quite high. Again, the consumers are not reading these documents very carefully and maybe not making the most informed decision when they're contracting for this. They're also being told they're going to qualify for rebates that may or may not exist. And so it's really a question of just making sure that that sales pitch is being done in an ethical manner and making sure the salespeople that are out negotiating these agreements are registered salespeople, because we're finding a lot that they're not. They wouldn't qualify because they have criminal backgrounds. There's a lot of money in California today in solar, and it's just a matter of working together with our industry partners to make sure that we identify the predatory contractors early on and get them out of the marketplace. So that's kind of an update of where we are with solar.
Thank you, Dave. Frank, I know you've been very interested in solar. You have any comment?
Yes, I do. I've been doing a little research on this myself, and I find that some of these salesmen, even though they're selling the system, are projecting 8% utility rate increases to make the performance work. They're overselling the customers on what they should be getting. Solar is a wonderful product when it's done, represented properly. I watched a commercial the other day on the national news programs, and here comes a solar commercial on, and there's a beautiful cut-up roof. It's very high-end home, and they're basically touting American products, and you want to build with American products, and what a wonderful job they've done. And I'm looking at the installation, and in the background I can see half of the panels that they put on this roof are shaded. So they've oversold the customers. A solar panel is absolutely worthless unless it's in the sun. So the customer is paying for this complete system, and they're not, they project these returns years and years down the road, and they're gone. And by the customer is stuck with this, they've overpaid or over-provided what they should have had. And it's a very complicated situation. I don't know how we regulate salesmen who make these kind of presentations. I'm sure, they get paid a commission, and the bigger the sale, the bigger the commission. And that, unfortunately, I think it's a little bit of the Wild West out there. And it's it's very hard on the consumers when they don't get a good contractor that's doing it properly.
Question or comment? So the PUC suggested that we focus on the problem. And we had talked on the phone about the possibility of holding a stakeholders meeting that might help us root out some of the problems, not just as discussed here, because there's other problems besides building houses in the shade or in treed areas, but, you know, having the right pitch of a roof, having them oriented in a direction that they're supposed to be oriented. Those are the, you know, day-to-day issues. But I'm just wondering if this committee could, and you, Marlo, would be interested in encouraging a stakeholder meeting that might cover this and possibly, I don't know, you know, what our time constraints would be, but we were very successful last year in a stakeholder meeting in November around the Berkeley balcony collapse. It was a great day. We had a lot of folks show up, and a lot was at least brought into up to the surface, so we could at least find out what all the problems are and who all the entities are that are involved with this.
I think, you know, stakeholder meetings are very valuable at certain times, but I think at this point, I'm just a little concerned about holding a stakeholders meeting because it's like David was saying, you know, education is really the key right now. Getting a package of education out there, at least on our website, just telling them, you know, these are the issues you need to look at when you're getting a solar system installed or something like that. I think that's really critical. And the other thing, too, about a stakeholders meeting is that it does take a lot of resources. And so, I mean, if it is something you want us to consider, I would really not want to rush it too much, because I'd want to make sure that we have, because we do have the reporting of settlements coming up that we have to report to the legislature on. So it's like we have a lot of projects there, and so I really want to make sure if we do a stakeholders meeting, that number one, that it's timely, and number two, how, you know, what kind of resources do we have to do it? And number three, is it really something that we need to do right at this time? So is it something that we could go look at? I guess that's my question. Just to comment on that, I think the outreach is going to be probably where we're going to get more of the benefit. I know Rick has been doing a great job as far as putting information out there to the public. I think we could focus a little more on, again, some of those things we just mentioned as far as solar and things that we could look for on all of websites and other social media. But also, if we were to do a stakeholder meeting, I think it would probably be more beneficial not to do it as a kind of an information type of setting, but to let them know that we are well aware of some of these predatory practices and promises, and that we will be conducting investigations, and anyone caught doing such, you know, will face those consequences. I think maybe just kind of putting it out there in that format, opposed to educating them. They know what they're doing, and they're doing it because it makes them a lot of money. So we all know that, but I think just to kind of let them know that we are aware, and this is what we're going to be doing, and the consequences, I think would be probably more beneficial. Any board comments on that issue?
Madam Chair, this is Pastor. You know, I do agree with the comments that are surfacing here on this solar issue. I know I attend many of the senior scam stopper sessions, and that's one of the issues that really surfaces at these meetings. And the question is asked, how many of you receive calls at home for different offers? And the number one call that they get is from solar contractors or a salesperson offering them some type of a system. So I do think that education is really a high priority at this point for the contractors board to try to put some information, and I know Rick has been working on this, on the website, because we need to get consumers educated on this whole issue. And with our partnerships with the PUC and others, the association, I think that's a very, very important first step. As far as the stakeholders meeting, maybe I agree with Cindy that this takes a lot of resources, and maybe one of the strategies might be that we first consider is preparing some type of a white paper on the issue based on our complaints, and maybe offering some recommendations for legislation in this area, and prepare that white paper for the legislature. And maybe there will be a take by one of the legislatures to hold hearings, or maybe have some type of a meeting on this issue. And that might generate additional type of interest by the legislature and the public itself, or just people interested in this issue. That's just something I put on the table for maybe consideration sometime in the future, because a white paper sometimes really is so effective, and people need to know what the issue is before they can act on it and really offer some good solutions. That's my comment. Thank you.
Thank you, Pastor. Any other board comments on this item? Public comment?
I don't know if we're going to get into the discussion of the electrical energy storage systems, but these are high energy systems that have to have knowledgeable people install them. And I'd like to make a motion that we have energy storage systems added to the electrical contractor's license definition of scope of work. So that
I'm sorry, but that's actually not on the agenda for this meeting.
Electrical energy storage systems are on the agenda. I'm reading the thing right here.
Right, but you're saying adding something to
I'm asking that we make a recommendation to the main board
to pursue a regulation. Is that what you're thinking?
To add to the license classification for electrical contractors C10 energy storage systems.
Right, but this is just a review of the classifications. So I think that you might want to have another meeting where you actually discuss modifying or adding classifications relating to the storage issue. Because what you're talking about is, to me, a little bit
I have a
more.
suggestion.
Go ahead.
It looks like it's on the agenda to me.
Well, I have a suggestion, Frank. We could put that as, if you would like to put that as an action item on a future agenda, we could put it on the board meeting agenda.
Okay. If we can't do it now, all right.
Okay.
Same result.
All right, thank you.
I hope so.
Moving on to agenda item G, review.
Discussion on the classifications yet, correct? F2?
I thought we just did.
Well, the reason why we put this on the agenda, I apologize if we didn't put on the agenda appropriately, is because we become aware of these storage systems, and these storage systems are critical to the solar industry. We talked earlier about systems that are generating power when you're not home. You need to be able to store that power in some fashion. And the board has received a lot of questions from industry as to the appropriate classification. So this is a kind of a summary of what the licensing staff have been telling industry inquiries regarding the appropriate class. And as it stands today, the C10 would be the appropriate class to contract and install an electrical energy storage system, whereas there are other classifications that can install a solar system that generates the power to store the power. It's restricted to the C10 class unless it relates to like a public works project or a structure to house it, and then a contractor could also contract for it. So this was there to just make sure that the committee and the public are aware of the classification decisions that are currently in place.
Thanks for the clarification. I think that's what Frank was trying to do, so that's why I skipped over it.
Right. I think, you know, from reading the materials, what I got was that you were trying to answer the question of which license would be appropriate for this type of work, not to amend or change the definition for C10, which is a regulatory change. And
Right.
that's what I was talking about. But I didn't hear Dave go over that piece. I thought we hadn't actually discussed the background issue. That's why I wanted further clarification. Thank you.
No problem. You have a comment, Pastor? Oh, sorry, public comment.
Good afternoon. It's been a longer morning. Eddie Bernacchi on behalf of the National Electrical Contractors Association. And I want to thank the committee for putting that item F2 on the agenda, and the staff's report kind of clarifying there, because the industry does need clarification on this. You know, not just for our contractors, but for the consumers and our customers that we provide these systems for. There is some confusion out there in the industry. Unlike the A classification and the B classification, which are quite broad and cover more of the facility, the specialty classifications do get into the specific construction technologies that are available. And the energy storage systems and the microgrids, which are an emerging technology, are becoming very common, are glaringly absent from the specialty classifications. And so to keep contractors out of one of Mr. Fote's future reports at this meeting and at some time in the future, we don't want to keep these people operating outside their classifications, we would really encourage the board to look at clarifying those technologies in that C10 classification, just so the customers know what contractors should be performing this, the consumers know, so there's protection there, and so the contractors know, so we don't have contractors out, operating outside their classifications and running into issues with the board as well. So we'd appreciate if you would look at that, and do appreciate you adding that to the agenda today.
Thank you for your comments. Are there any other public comment on that item?
This is a subject very dear to me. I'm Dan Koke, PDE Total Energy Solutions. We're a 25-year-plus contractor doing battery energy storage at the largest military microgrid, Type 2B in the country at 29 Palms Marine Corps Base. We're building NAVFACs for the Department of Defense military microgrid test bed at Port Hueneme currently right now. We just finished Los Angeles Department of Water and Power's first battery energy storage project that went completely through plan check through the city of Los Angeles and the county of Los Angeles as well. So I just want to reiterate, as the industry is growing with the large amount of solar being installed in the state right now, that batteries are a key core component of the electrical infrastructure now. AB 2514 has specified that the utilities deploy megawatts after megawatts of battery energy storage because they are critical assets that the utilities use, both distributed and centralized, to have reliable grid in California. That being said, these systems are new, they're very complex, and they take in-depth understanding not only of battery technology, but of the existing AC electrical infrastructure to integrate them both safely and reliably. So to minimize both property damage and life-threatening injuries, very strict core competencies and training is required for these installations. Thank you.
Thank you. Any other public comments?
Thank you for the opportunity to speak. I'm Dennis Moore, and I'm the director of the Sacramento Electrical Training Center here in Sacramento. And as I heard somebody proclaim earlier, their business is science. I guess my business is training in the business world. That's kind of my trade. I been a training manager at PG&E, for Naval Sea Systems Command in Washington, as well as for Bechtel, one of the large engineering construction companies. And yes, this new battery storage technology is a big deal. It's new, it's complex, you just heard that. What we do is we provide that training. At the Electrical Training Center, we train electricians. There are many of these training centers throughout the state that train electricians on how to properly and safely install the electrical systems and the generation systems. Most importantly, we emphasize our safety for the people that are doing the work, but even more importantly than that, from the consumers that are going to be using the product when it's turned over to them. This is an issue that we definitely would look for support in providing clarity so that our contractors as well as the general public know who to go to, as this is definitely an emerging technology that's going to be of high safety and hopefully not another solar concern that we just heard about here for the last on the reports. Thank you.
Thank you. Are there any other public comment? Come on.
Thank you, Madam Chair, members of the board. My name is Mike Johnston, and I work for the National Electrical Contractors Association out of Bethesda, Maryland, in the D.C. area, and I'm the executive director of Standards and Safety for the entire organization. And I'm here to support the folks who are talking on behalf of the expertise, but I also want to express to the board my position with the NFPA chairing the NEC Correlating Committee, which develops the National Electrical Code. I chair that whole committee, and we've worked for the last 2 cycles to make sure there are rules in the National Electrical Code that can be applied specifically to energy storage systems and microgrids. It's 2 cycles worth of work. It was 6 years in development. The 2017 edition of the NEC is equipped nicely with those rules to apply to those installations and systems. And it's complicated. As Dan mentioned earlier, the expertise that's necessary is related to emerging battery technologies. I also serve on the UL Electrical Council. The battery technologies that are being developed are sophisticated, and if they're not handled properly, they behave violently when they're installed within buildings if they're not monitored and maintained, in addition to any installation criteria. So I want to talk in support of what they just mentioned. The other thing I want to mention, and it aligns with the training director's comments, the National Electrical Contractors Association, along with the International Brotherhood of Electrical Workers, has aligned efforts with Penn State University in developing advanced training curriculum for energy storage systems and microgrids because it's necessary. It's necessary to take our existing journeyman wiremen and contractors who already have the prerequisite expertise and advance it to levels where they can handle and manage these systems so they're safe for people who occupy those buildings. Thank you for your time.
Thank you. Are there any other comments on this item? Okay. Just for the record, we will be deferring that to the licensing committee to review, and all of your comments will be taken into consideration. Thank you. Moving on to agenda item G, review, discussion, and possible action regarding enforcement strategies to reduce service and repair contractor deceptive tactics. I'm very pleased to see that enforcement is continuing to address the enforcement strategies to reduce service and repair contractor deceptive tactics. It's a very serious problem, and committee member Joan Hancock has a lot of insight on this and has put a lot of input, and we appreciate that, Joan. Dave, can you please give an overview?
Yeah, so we look at page 62. I just want to do a real quick overview of the problems that we're encountering and the laws that are currently in place. I'm going to start off with some good news, though. The board did direct enforcement staff to create a service and repair task force. We did that. We worked with our industry partners. We developed partnerships with DAs. We had DAs that joined together to address the statewide predatory service and repair contractors, many of whom are unlicensed, to issue location search warrants to get prosecutions of those individuals. We also work with our public affairs office in doing all that we can to educate both industry and consumers. I just want to mention that I think one of the most effective things that we did is we had an industry meeting, and that was put together by our industry partners, and it had most of the larger service and repair contractors in the state at that meeting, and we talked about how they need to provide effective consumer response when there's a problem. They need to be very clear with the contracts. We talked about the electronic contract forms and how they need to make sure that their customer has a complete copy before any work starts. And I think all of those actions that we've taken have been very beneficial, and that's demonstrated by a 19% reduction in service and repair complaints since the development of that task force in 2015. Now, there are still some problems, and I just want to quickly touch on those, and I'm going to let you know about the laws that are in place, and Joan, I think, will say a few words about what we should do next. The first issue would be what we call it service and repair franchising, and that's where you have someone, a contractor, that has set up numerous name styles. This used to be more prevalent with the yellow page ads, where you think you're calling 3 contractors to come out and give you a bid. Reality is all 3 of those contractors may be owned by the same individual, just operating under different name styles. So we have that. We're looking at how many licenses are currently issued where the qualifier is on more than 4 of them. False advertising, that's been a problem. It continues to be a problem where someone says lowest rates or no extra money to come out at night or on weekends. It's misleading. There's a law in place, 7161B or A and B actually. They talk about making a false statement to induce somebody into entering into a contract. And so it does relate to those advertisements if they're not true and correct. The high pressure sales tactics, real problem in that if you have a blown breaker and you're not familiar with electrical, you call somebody out and they tell you that you need your whole panel replaced. You may be inclined to do that when it's just a very small repair. Same thing with a heater. Heater's out in the winter. They tell you the whole system needs to be replaced. They're using high pressure sales. They come out on these jobs though as a service and repair contract, and this is what we really want to take a look at, is that you can go out for a response to a service and repair call as long as the value of the work is less than $750. You don't have to provide the 3D right to rescind. The salesperson doesn't have to be registered. The problem, though, is when you go out to replace that supply line to that faucet, and then you decide you want to do a remodel of the bathroom or kitchen, and you want to exceed the $750, the consumer you are required to give the consumer a 3D right to rescind. That doesn't always happen. They use high-pressure sales. The salesperson that's doing that isn't registered, hasn't had any background check, and so we're finding that that does continue to be a problem, and that's 7154 at the bottom of page 63, the discipline for employment of unregistered salesperson. As interesting as this is, if you're an unregistered salesperson, you can be charged with a criminal misdemeanor. The employer of that person is charged with an administrative action. It's not criminal on their behalf. I don't know that it should be, but I just mentioned that we want to make sure that the salespeople, they have had the fingerprint check, that they don't have criminal records that would bar them from being a salesperson, and that they're not somebody that's been revoked. That's so important. It's not uncommon that somebody has had their license revoked and now they want to go out and sell for others. And the problem is they're engaged in the same type of behavior that caused them to get revoked, and that is taking excessive amounts of money and not performing any work. On page 64, we talk about the 3D right to rescind and how it's misused. We've all been in a situation where we've called out somebody to our house, and we just want that work done now. And so they can't sign an emergency waiver, but the reality is it needs to truly be an emergency and not somebody making a false statement. And we go back to the misrepresentation, saying, we have the complaints where somebody says, if you don't contract with me right now to fix this electrical problem, I'm going to turn your power off, I'm going to remove your panel. I mean, that stuff like that happens. And so they're really motivated because they don't want to be without power or they don't want to be without water to make a decision right here and now. And we've had a case recently where somebody called about a kitchen faucet leak, and it's a really sad case, but they ended up signing up for $30,000 worth of unnecessary work. They really couldn't, they're elderly and they couldn't pay for it. It's just a tremendous problem, and arguably they didn't need the work. Same thing when they say you got to replace all your main line because you've got a blockage in your plumbing. Well, you probably didn't need to do that. The problem is that once they've done it, the evidence doesn't exist to determine if that's correct or not. But I want to say this, we are watching those cases very carefully, and we do our own undercovers when we think somebody is unnecessarily attempting to contract for work without being truthful as to what needs to be done. But that's where the 3-day right to rescind, it is a problem. It's not as effective as it could be. It's something we can look at more carefully. On page 65, we've already talked about electronic signatures on contracts. And I want to just thank Joan for her insight in helping us put this section together, and also for her ideas on the matrix at the end. So Joan, would you want to share some of your thoughts from the industry and also from a public perception?
Well, I may have jumped the gun on my idea about a stakeholder meeting in the solar field, but surely it may be more appropriate to include some of those people that are getting ripped off in the same way that we're seeing in the service and repair industry. And so I really hope, you know, the board can consider something like a stakeholder or whatever, so that we can join with the necessary partners we need to, if even and just for the sake of broadcasting and advertising this. I mean, everyone is affected by it. But I really appreciate the fact that you went right down the list with some of the things that we talked about originally. When I threw out some ideas, I saw everything as a staged, like what happens before work begins and what the events that lead up to some of the bad actors and acts as a result of these people that are, you know, called upon. My passion really is for, you know, more vulnerable people who either maybe have a language barrier, maybe they're elderly, or are in a vulnerable situation where it's an immediate action that needs to be attended to. And I don't know if the answer is to have, you know, a little bit better or enhanced response, penalty, citation, or whatever to those situations. The thing, and many of you know this is kind of personal to me because it happened to a member of my family, and more than once. You'd think they'd call their contractor sibling, but yeah, we're all very independent. But so before the work begins, you know, some of the selling practices that are just to get the foot in the door, you know. There's a difference between when somebody comes to your house and they're really, are they setting up an appointment or are they doing sales? So I think something needs to be outlined in that area, because I see that happening. It's happened to my home. Once that person gets us inside, what is really required of that person? I mean, you have a contract. You know, they're coming into service in the situation that occurred in my family, coming to just do a routine service. Well, all of a sudden, it's not a routine service. It's a complete replacement of infrastructure, and without getting into details. And then not just that, you know, quadruple the normal cost to get a replacement done, financing contracts in addition to that, and interest rates charged on some of these contracts that are just, you know, beyond usury laws. So I think we have a lot to talk about. I don't know what the format is going to be going forward, but just in what leads up to the actual work that gets done, and the necessity of the work, the strong-arming, those tactics to get the work started. And then, you know, now you're at the, maybe it's 3 phases, now you're at the contract stage, and you have, if you've seen those formatted contracts, what's on them, really, and how explicit is the work that the person is about to perform, how explicit is that work stated? And perhaps, you know, there may need to be some sort of requirement that really elaborates that work that is being done and necessitated by whatever infrastructure failure there is to be repaired or replaced. And maybe that needs to be done under penalty of perjury. Okay, so, and then advance to the next phase, which is the cost of doing this. You know, these egregious and charges for maybe something as simple as replacing an electrical breaker or a kitchen faucet or an AC unit that goes down instead of replacing entire systems. And going forward from there, I can just go right down the list, and I don't want to elaborate any more than what needs to be, but this is a real problem. It's getting worse. The 3-day right to cancel with these waivers and electronic signatures, I'm concerned about that. You have vulnerable sectors of society. They are about to sign away on a contract, and if they need the work done, in order to get it done, they have an opportunity to sign a waiver to that 3-day right to cancel, meaning they no longer can cancel. Maybe we should have some sort of cooling off period for that certain sections of society, segments of society. I'm all for going forward with harsher, stiffer rules and penalties, however we can, as a board, agree on them. And I'm really pleased that you guys have outlined this, and I hope to see a lot of support from, I know this is something that you, Pastor, have been historically very involved in, and I'd like to know what the rest of the committee thinks about some ideas that we could come up with above and beyond a white paper.
Is there any other board discussion on this item?
Madam Chair, when I reviewed this on page 62, 63, and so forth, it outlines the problem that we're having, and you explained that very well. I don't know at this time whether or not we have the adequate feedback except to continue to publicize this as we have been, and let PR take and run with it. But it says the Service and Repair Task Force to address these concerns. And I think it's the first time I've seen it laid out this well, and it really goes to each item that you address in this, in the last 3-4 pages. So I'm all for monitoring this as a action to be continued and report back to the committee to see what can be developed from this, because at this point, as it reads, it says to address these concerns, and I think the Enforcement Committee has addressed them, and let's see what we can get out of them. There's some statistics, how many cases we have. Maybe on the phone calls, IVR, we can determine that it is a mass problem out there, and how can we attack it and let the task force do their work first. Yeah, that's all I have.
Thank you. I actually agree with you, and hopefully we'll start to see more numbers and maybe increase the task force if necessary. Yes, ma'am.
I just had a question for Dave. You mentioned that that the contractors who hire unregistered salespeople, you would pursue them as a disciplinary action. Have you ever considered having them criminally prosecuted for aiding and abetting unlicensed activity or registration? Because Business and Professions Code Section 125 might provide that kind of authority to the board to have someone prosecuted for aiding and abetting unlicensed activity.
Thank you. That's a great idea, and that's really what we want to have the committee consider is And on page 66, we have the matrix. We have, I think, what, five concerns. And what we would propose is that we would look at those even in more detail. And as Christy said, are there already laws on the books that would help us to be more effective with our enforcement? And if so, we need to train our staff. I heard from Doug earlier. I didn't know that, so I appreciate that. That's the kind of thing that we would look at and then come back to the committee and say, well, maybe we should incorporate into our training a module about recognizing these predatory practices based on the following criteria. Perhaps we should work with our industry partners in determining if multiple name styles is truly a problem. It may not be so much on the internet. This electronic contract signing, what can we do working with industry so we are sure that that customer actually reviewed that contract, that they received it? And that's what we emphasize to at the industry meeting. Just because you send it to them by email, you need a return receipt. You need to confirm they got that contract before you start work. And what can we do to make that 3-day right to rescind more effective? So if you're in agreement with that, we would come back to you after we look at this more closely, and you could review and approve or not approve whatever our plan would be. Thanks.
Thank you, Dave.
Marlo, I have one comment. On the contracts are very legalese and very wordy, and they're printed in the smallest type I think you could find on anywhere. And I was pleasantly surprised with the contract I had to read the other day, reading construction contracts all the time. They came with basically almost like an outline of what each section of the contract meant and what the effect was. It was just very general, in straightforward language, without the ands and ors and all the other things. I think a lot of people don't understand that some of these contracts are giving up their right to pursue actions in court. They're going straight to arbitration. A lot of people wouldn't give that up if they actually knew that, but you have to read into one of these paragraphs so deep that it almost makes you dizzy after a while if you're not used to doing it. And I think there may be some way that we can make them simplify the contracts or present something that the consumer could understand more easily, because most consumers do not read contracts. I mean, that's just the way it is. You get a 4-page contract in this type that's almost impossible to read, and, oh, will you please sign it now? I think maybe we could do something to clarify some of that.
Thank you, Frank. Any more comments?
Yeah, I have a comment. In addition to that, Frank, these electronic signature, imagine the situation. First of all, I can't, if you can't tell already, stress enough about how horrible this situation is. Elders, when they need something done at their house, they do not get on the internet. They go to the Yellow Pages, if there still is one, and they go to the newspaper. And the newspapers have advertising in them, and I'm not going to, get specific about which industries, but that's where they get their information from. So, I mean, think about who might be advertising in, newspapers and in the Yellow Pages anymore. The electronic signature situation, think of an elder that's sitting there about to sign a contract. They're just like Frank says. I mean, there's boilerplate, and the print is so small. But if you've ever seen like a regular service and repair contract, it could be 2 pages or 3 pages, and they're trying to read through all of this stuff on the first page to sign at the bottom. That they are okaying this work, and there's some verbiage about having 3-day right to cancel, and then somebody says, well, if you really want to do this right now, you need to sign this other thing on the back. Okay, now they've got a little iPad, right? And somebody's just, as you do with iPads and your iPhones and everything else, you're flipping forward, and okay, here's where you sign on the back. Have they even read that stuff? So, the reason I sound frustrated is because I am. I don't know who else besides us is going to get tough on this issue. It really involves our organization on every level. It's part of our mission to protect consumers and especially the most vulnerable ones. And I really hope to see, you know, as a group that we continue this focus. And I think we've got to do more than just monitor. So, thank you.
So I guess my question to you is there anything that you saw that you would like the staff to bring back in terms of a proposal to make any changes?
You know,
That's
this
the
idea
question.
that, this grid idea, you know, the purpose of putting this on the page was to find out where within our organization do these issues seem to surface, okay? Is it, you know, what in under unlawful advertising, staff redirection, okay, well, what does that mean? I mean, what do we mean by that? Staff redirection. What do you mean by that, David? I'm not sure what you're considering there.
Well, what I would be considering is taking one of our staff and just telling them that you're going to review the advertisements that are out there. Don't wait for a consumer complaint. Go to the internet, go to the Craigslist, the Sacramento Bee, look at the advertisements. If they're not truthful, or say somebody claims they've been in business for 30 years, but the license was only issued last year, we can address that proactively. It would be about identifying one of our existing investigators or consumer services representatives to focus on that issue and to report back on the success that they've had. I mean, I would create a baseline. We would look at, and we could use the internet or Craigslist or something and say, based upon what we've seen, we've got X amount of what we consider to be illegal advertisements for the following reason. By focusing on those, we were able to reduce that down by 80%. But it would be redirecting staff. And a lot of what we talk about here, whether it's solar, service and repair, SWIFT, I mean, it's about what our focus is going to be. And so that's what it would be, identifying someone that would focus on that issue and then report back on the success.
So just to answer your question, for all of these things that appear on this graph, no, I don't really have specifics. I don't know who in state government has really their thumb on, is it Department of Aging? That's why I proposed maybe having a stakeholder meeting, just for those vulnerable entities. I think it's a lot bigger problem than we're willing to admit. And I don't, okay, we can monitor it and just, you know, keep moving along at a pace. We started this when I was first on the board in 2007. We started this. We continued it when we had the walk-in bathtub dramas. And, you know, I think we've got to do more than just watch it happen. So, and I'm not sure, you know, as just an individual board member, what kind of changes we are really authorized to make without having any support from you know, our legislative liaisons. Maybe, Laura, you could be helpful there. And I like the idea of having a stakeholder meeting on this, and perhaps at the same time we can talk about the solar issue.
Madam Chair, this is Pastor. I have a comment.
Go ahead, Pastor.
Thank you for the presentation on this issue. And Joan, I share your concern, and thank you for trying to rope me in here. That's no problem. You know, I think our concern here is really, as you mentioned, it's really impacting seniors, and primarily because they seem to be the most that are victimized by, unfortunately, these unsettling business practices by the industry in some cases. I did want to maybe look at this matrix. I mean, I think it has to be reworked somehow, because I think for us to monitor or maybe make some recommendations here, we have to put numbers into these boxes. You know, I mean, is the issue really on the misrepresentations or the advertising? Where's the problem coming from? and then how to direct this with the top horizontal boxes. Maybe we need to expand those, revise those, because I had a problem trying to figure out what this matrix was going to do. So maybe, I mean, I don't mind talking to David or maybe to you later on and see where we want to go here as a first step, and then maybe get the data that we need to move forward on maybe making some additional recommendations.
Thank you, Pastor. That was kind of what I was thinking too, I think, and that's where David and his staff were coming from, is perhaps sitting down and prioritizing all of these issues. And there again, you know, with David looking at his staff and his staffing resources, because, you know, you redirect somebody from one area, is there going to be a backlog in another area? So I think it's really critical that we do get some type of prioritization and maybe not even put it in a matrix format. But I think this was a good start in terms of just getting the discussion going, because there is a problem out there, and I too have elderly parents. Unfortunately, they call me before they do too much, but I wish I could get my dad to stop driving, but that's another issue. So anyway, I think it's a good start. Call your mom.
Thank you.
Okay, thank you. So, Pastor, maybe you can get with Dave and try to put together a different type of matrix where we prioritize and get some data in there, and then just kind of move forward from there. And then you could report back for the next committee. Are there any other board comments on this item? Public comments? Motion to adjourn.
So moved.
That will conclude today's enforcement meeting.
You have to do a roll call.
Roll call, excuse me.
Kevin Albanese, absent. Susan Granzella, absent. Joan Hancock. Aye. Pastor Herrera.
Aye.
Ed Lang.
Aye.
Marlo Richardson.
Aye.
And Frank Shetter. Aye. Thank you. Motion carries.
Now that would conclude the meeting. I've been wanting to do this.
Yeah, let's start this week.